can resume the inquiry now, please. I'll just run through a couple of housekeeping items before we continue with evidence from our witness. So, Mr. Beglin handed me the extract from the planning practice guidance that we discussed yesterday regarding biodiversity. Again, I've only got a copy of that as well.
Yes, thank you.
Thank you. Any comments on that, Mr. Beglin, or are you quite happy that's just what you essentially said yesterday?
So yes, that's the only part of the PPG that I need to refer to that's not already in the core documents.
Thank you. And I've just dropped into my inbox just now the felling licence.
Right. I was just about to ask whether that had come. Well. I hope anyway that Mr. Beglin received that from us yesterday evening at some point. I'm sorry it was slightly later than I hoped.
Yes, it's around the time of homework, isn't it, into the evenings? But no, I was grateful to receive that. So we do have some printouts of it that I can supply you with now. You will see when you check it against the electronic PDF that's been sent to you that it's not quite in the same format, but it will contain, I think, all of the same information. So it's a question of whether you prefer to use the PDF or...
I'll probably stick with the PDF if it's the same format, but I only had one question, is it doesn't seem to have condition B on it. It goes straight from A to C.
A to C.
Yeah.
And I don't know if that's just a formatting error or if that's just
I think
Forestry Commission.
I'll check, sir. We identified it. I'm not sure that it may be because it wasn't applied. I don't know, but that's the inference that we drew. But I'll check, sir.
Thank you. And it was suggested yesterday there might be an online contributor. Is that anyone attending from Teams or anything like that? Do you know?
So for our part, no. The obligation is now, has been for some time, I think, entirely agreed. There's an explanatory note. So on that basis, we don't need to waste any inquiry time. So no one will be attending from me. And I understand, although I'm not acting for the county, that they're not sending on anyone either.
Okay. Okay. Anything else? Oh, we're happy to carry on. Okay. Thank you. In that case, Mr. Beglin, was your cross-examination. Ready, thank you.
Thank you, sir. And good morning, Mr. Allen. Just in terms of a list of documents, sir, to have ready, the felling licence that we've just been talking about, the two sections of the PPG, I think core document 3.9, and then the LNRS excerpt, documents 3.4, 4.7, 4.8, 4.13, 5.1, Mr. Fagan's decision, and 5.8, the Fairfax challenge. So I having read that fairly long list of documents, you'll be comforted to hear that, as I indicated yesterday, I'm not going to trespass, or try very hard not to trespass on anything that was dealt with yesterday, and just gratefully adopt cross-examination of Mr. Cosgrove. So bearing that in mind, Mr. Allen, if we turn to the felling licence first of all, have you had an opportunity to look at that now?
Yep. Yes, I have.
Thank you. So we see in relation to this licence that it's relatively recent, dated the 12th of July 2023. It deals in the opening paragraphs with where there is provision for restocking. So there are examples, aren't there, in the schedule later on where there is specific provision for restocking, but it's not a general provision within this document.
That relates to two areas, but yes.
Thank you. And so as we go through and we look at I'm on page 3 of 10, got some page numbers in the bottom. We know that the permissions in the licence expire 12th of July 2033.
Yes.
Just while we're on licences that have expired or been discharged, in relation to a parcel of the land that isn't contained within this felling licence, I think you will have heard Mrs. Scott refer yesterday to an earlier licence. Do you know anything about that earlier licence or the terms of it?
In terms of not this licence, other than this,
you hadn't seen it. Thank you. Then I won't ask you about it. All right. Thank you. As we carry on down page 3, penultimate paragraph, we see this. Any felling operations for thinning approved by this licence must be implemented evenly across the felling site, and so it carries on. The felling operation for thinning will not exceed 30% of the total number of trees or remove more than 30% of the original canopy cover per operation, unless otherwise agreed by the Forestry Commission and confirmed in this licence. So that's the baseline, but subject to change by agreement.
Yes, yeah.
Yes.
That, as I read it, that provides a cap on what can be done under this licence.
Subject to further agreement.
Yeah.
Thank you. And then we see that the licence is signed off. That's page 4, 12th of July. And then we have the schedule. And just before we look at the schedule, if we look towards the end of the licence, what we see is the map that corresponds to the schedule that we're just about to look at.
Correct.
And the numbering may not be terribly clear on people's individual copies, but we can see, for example, that 3A, if we look at that, that's the gorse, isn't it, on the operations map?
Yes.
And then we have the woodlands to the west of that, and we have parcel 4. You see where parcel 4 is?
Yes.
Going on to Theobald's Road. And then we can see sub-parcels within 3 as well, and then more remote from the site, just so that we locate them when we look at the schedule, we have 10A, 10B and 11 towards the bottom right corner. Yeah.
Yes.
So in terms of what is being allowed by this licence, we have 2B and 3A. If we look at those first of all, on page 5, we can see, can't we, where there is provision simply for thinning, and then when there is provision for regeneration as well, because we can contrast 2B and 3A
Yes.
in that respect. Thank you. And then if we look at what the inspector may consider are the two most relevant parcels for site immediacy, 3C and 4, we can see what's being discussed there. 3C thinning of up to, almost 5 hectares of land, estimated volume metres cubed 260, and then in relation to parcel 4 we see 3.2 hectares 40 metres cubed. So those are, by way of example, the kinds of areas that are subject to up to 30% thinning under this licence.
Yes.
Now, in terms of what has been done to see what impacts that might have, we know that there's no ZTV of the potential development. We know that's right. Yes?
Yes.
And I think you're going to tell me that there's no evidence that anyone on the appellant side has analysed what 30% loss of the trees might be in, for example, parcel 3 and parcel 4 that we were just looking at. Correct?
That's correct.
Yeah, thank you.
I mean,
And yet this licence has been in existence since July 2023.
Yeah, I mean, I'll just point to what Ms Brockhurst said about that in terms of clearly there has been some works done on site. You can see that that's come up in examination. As I understand, and based on what Ms Brockhurst said, that licence and those parts has been fulfilled. So in terms of a site visit, you'll be able to understand visually what that looks like.
Well, okay, let's test this. I mean, is your evidence from your own knowledge, first of all, that in relation to the various parcels that are on this operations map, that all of them have been thinned out by 30%?
Well, I haven't gone and looked at it, but in terms
And no one's confirmed that to you in writing?
No.
You don't know that's the position?
I don't know that.
No. But what we can see, and what the photographs clearly show, is a significant amount of deforestation that appears to have taken place relatively recently, which would be consistent with the date of this licence. And no one has assessed formally on the appellant's side what the impacts of that are.
I mean, I wouldn't class it as significant. I mean, there's been thinning.
Thank you. Now, none of that says anything, does it, about what a new owner of the land, if it were promoted for sale for potential residential development potential, might want to do in terms of bringing any of those parcels that are identified in the operations map forward?
In what sense?
Where it just doesn't give you an indication as to how they might
No,
promote.
I mean, you look at it on face value. This is a licence that relates to tree thinning works in general on that part of the woodland.
Yeah, okay, thank you. That's what I wanted to ask you about on the felling licence. We're going to turn back briefly to Greenbelt guidance, and we're going to look at the MPPF first. And again, my temptation is to take you straight to paragraph 159, but I'm going to resist. And I'm going to start at paragraph 155. So we're all familiar with the way that this runs now between paragraphs 155 and 160. The first point to make is that these paragraphs, like some other paragraphs in the MPPF, provide for an exception to the general rules about inappropriate development that apply to the green belt.
Yes.
Yeah? Thank you. And that is reflected, isn't it, in the nature of the requirements that we see in paragraph 155, because first of all, there needs to be development utilising grey belt land, as well as not fundamentally undermining the purposes taken together of the remaining green belt. So just pausing there for a second, those are two separate tests, aren't they, for the purpose of Lim A?
Yes.
Yeah. And so the point about undermining the remaining greenbelt fundamentally, that would be a way of taking yourself outside of being grey belt land, even if that land weren't making a strong contribution to purposes A, B or D.
Yes.
Thank you. B, demonstrable unmet need. We don't need to spend time on that. C, sustainable location, but it is with particular reference to two identified paragraphs of the MPPF. So there's a particular focus on the question of sustainability there, which also has to be met under these rules. And then, where applicable, the development proposed meets the golden rules requirements set out in 156, 157 below. So it's not a question of whether or not something makes a contribution to those rules. The rules have to be met, and that's a requirement in order to fall within this exception.
Yes.
Yes?
Yes.
Now, as we follow the logic of what happens in the following paragraphs, 156 and 157, Mrs. Scott told us about this. We can see what's set out there. Then 158, we have what the result of compliance with the golden rules can be. And then 159, we have a paragraph that is dealing with the application of the golden rules. I mean, that's right, isn't it, from the first line? There's no escaping that.
There's a cross-reference, yes.
It's not a cross-reference, is it? Improvements to green spaces required as part of the golden rules. This is an integral part of the overall test. Mr. Allen, we must be able to agree about that.
Well, no, I mean, I don't read 159 as being it's a requirement of the golden rules. Otherwise, it would have appeared in 156C.
Okay, so
Because the weighting attached at 158 is a conclusion on that. You achieve the golden rules, you attach that weighting. Moves on.
So I'm paraphrasing slightly, but I think the way you might have addressed this earlier in your evidence is to say that 159 is a nice to have.
In effect, it's you know, in addition, if you achieve golden rules, which I'll be saying we do, and which is agreed with the council, then that element of the golden rules, i.e. the open space element, should seek to also do that, i.e. 159.
It's been suggested to you before, and I'm not going to do it 4 times in one way or another. I'm only going to do it once. It's obvious, isn't it, that 159 contains a explanation of the requirements that the golden rules impose in relation to the provision of green spaces.
Well, no, because as I said before, you know, the guidance is clear at 155D. The relevant paragraphs for the golden rules is 156, 157, not 156, 157, 159. So it can't be read in the same context.
Thank you. If I'm right about that construction, if the inspector, and it's a matter of law ultimately, isn't it? So you and I can debate it till the cows come home, but ultimately the inspector's got to get the law right on 159. But let's assume the inspector agrees with the way that I've formulated it. If that's right, then in order to comply with the golden rules and in order for this site to be potentially not inappropriate development, it has to do the following things. The inspector has to form a positive view that what has been done here in terms of the green spaces amounts to improvements that contribute positively to the landscape setting of the development. First of all, he would need to reach that conclusion. Yes.
On your
yeah, these are all
approach.
hypotheticals.
Yeah, there's three parts of that. Yeah, no.
Okay, but we agree. Thank you. Secondly, he would need to form the conclusion that the improvements to green spaces support nature recovery. All right? Mm-hmm. And then thirdly, the obligation in relation to meeting standards, whether they be local or national. Right. So we agree about all of that on my construction.
On your construction, yeah.
Thank you. Now, if we turn therefore from there to the PPG in 3.9, and let's go first of all to the golden rules guidance that is at the end of that section. So last 3 pages, 10 of 12, 11 of 12 and so on. And tell me when you're there.
Yeah.
Right. So as we move on to the guidance, how can major development on land which is released from the green belt contribute to accessible green space? Following contributions should be considered. New residents and the wider public, so it's not restricted, is it, in terms of how this this green space is going to be accessible. It's not simply the new residents, it has to embrace the wider public as well. We can agree about that.
Yep.
And they have to be able to access good quality green spaces, so there is that qualitative reference as well. Safe, visually stimulating and attractive. So that's part of the guidance that the inspector needs to address. And then if we go down to the 4th bullet point, proposals, sorry, I'll wait till you're there.
Yep.
Proposals should consider how the creation or enhancement of existing green spaces can contribute to the priorities for nature recovery set out within the relevant local nature recovery strategies, providing greater benefit to nature and contributing to the delivery of wider environmental outcomes. Now, pausing there, there is no part of the evidence base, either in this application or within this appeal, that shows the appellant expressly considering how creation and enhancement of existing green spaces contributes to the strategy that is now adopted.
No, there isn't. But I think the timeline is important to understand here. So obviously, the nature recovery strategy was only published in its final form weeks ago. We submitted the planning application in September 2024, the appeal in October last year. At that time, it was in draft. There was a consultation. It's a fact that the design evolution was as it was.
Yep. So the draft was available at that stage when the application was being assembled, and when it was
No. The application was submitted a year before. So as I understand it, there was a consultation on the recovery strategy mid last year. We submitted in September 24.
Yep.
So it was just going through the process as we were submitting the appeal.
Okay. And yet there is nothing, so at the process of submitting the appeal, there is nothing in terms of revision of the appeal scheme or anything within any of the appeal documentation that shows that attention was expressly given to
Well, I don't
these
see how we
provisions.
could. The decision, we were appealing the decision based on the scheme that was submitted. So I'm not sure what mechanism, even if we wanted to or were able to, we could have done in the appeal context.
All right. The inspector has to apply this guidance as it appears now and consider the extent to which these issues have been taken into account, because we have an adopted strategy.
Yeah, it's in place. It's a consideration.
Thank you.
Sorry, Mr. Beglin, I'll step in if I may.
Yes.
Apologies. So if that hasn't been fulfilled as part of the appeal submissions, is that recoverable in condition or planning obligation?
In respect
That
to...
consideration of the reserved matters, this is an outline application.
Yeah, I mean, there's a parameter plan. There's a condition that seeks general accordance with that parameter plan. So there's that mechanism through the detail.
Thank you.
Okay, but there's no, thanks, that's helpful. But there's no specific provision, is there, in anything that's going to be discussed later today to demonstrate how this consideration could be accommodated within a site where you know that the local authority's position and the Rule 6 party's position is that there is overdevelopment of this site, that there is a real issue with the quantum of development proposed.
Well, I mean, on the it's common ground for the
What's
council.
the answer to my question? Caveat by all means, but what's the answer to my question?
Sorry, can you repeat that? Sorry.
There is nothing in the material that's going to be considered later today in terms of conditions that shows, that demonstrates that that problem can be overcome, and that failure arises in circumstances where you have known for some time that both the authority and Rule 6 party's case is that this site suffers from overdevelopment by reason of its location for 195 dwellings.
To answer your question, no. But in terms of this is in the context of the Golden Rules. There's common ground for the council that the Golden Rules have been met.
Yeah, well, maybe, but it's not common ground with us.
Correct? No, that's fine. But I'm qualifying my answer, and that's my qualification, in terms of the importance of this issue.
The council's been too kind to you, Mr. Allen. Now, in relation to what that means locally, we know now, because we have the plan in relation to the LNRS, and if you turn that plan up, remember that was circulated, you may not have access to that immediately. Do you want to take
So
a moment?
the version...
Yeah.
Oh, no, I haven't got actually a copy to hand.
Just take a moment and let's make sure everyone's got that. Yeah, of course. And so what we see on the mapping is that the site is lying partially within one focus area and potentially also the residue in another focus area. But let's look at the focus area that we do have, and we know we have action 3 here: create more good quality neutral grassland over a significant proportion of the site. Right, and as has been agreed, I think, between all of the landscape witnesses, it is precisely the neutral grassland that suffers most as a result of this development. We can agree about that?
Yes.
Right, okay. So that's how we go about assessing the extent of consideration or potentially harm to the focus area insofar as it applies to the appeal site. Right. Next, let's have a look at the PPG in relation to nature recovery. Hopefully you've got that in just the 2 pages. Thank you. So towards the end, we've got how should local planning authorities have regard to LNRS in planning decision making. Material consideration, we agree about that.
Yes.
Especially where the development plan documents for an area predate publication. Tick.
Yes.
So it's especially relevant here. For the decision maker to determine what is a relevant material consideration based on the individual circumstances of the case, we can all agree about that. And in cases where there is a draft that has not been consulted upon, that has been consulted upon but not yet finalised and published, draft strategy may contain useful evidential information that can support appropriate decision making. So as at the 19th of February 2025, this was guidance from central government about the utility of considering not just the adopted strategies but also the drafts, correct?
Yes.
None of that done on your evidence.
Sorry?
None of that done on your evidence.
No.
No, we agree. Thank you. Next paragraph. What is the relationship between LNRS and biodiversity net gain? And we can see what's said there. the strategies will identify areas where habitat creation, restoration and enhancement will be most beneficial. So that's what's happened here, and that's what we see on the focus map, and we see what actions it requires in relation to the appeal site.
Yes, yes. So, I mean, it's obviously the extract there is very similar to the plan table that takes it to a wider area. But yes.
Yes. So insofar as we can see what's on the plan, it's relatively clear what the implications are for the appeal site. They can play a critical role in supporting off-site gains to be delivered in a way that maximises biodiversity benefits. So there is the prospect of dealing with this off-site in the same way that BNG can be dealt with off-site. But we carry on through the guidance. Next paragraph, the strategies are designed to promote the delivery of off-site biodiversity gain in the right places where off-site provision is needed to meet the biodiversity gain condition for development, and it cannot be met in full through on-site habitat enhancements. So here is a clear steer in central government guidance consistent with the approach that's taken in relation to various other material planning considerations, that what ought to be happening is, first of all, consideration of how these things can be addressed, and secondly, that they should be addressed on site. Thirdly, if they cannot be addressed on site, not if it's more advantageous to do it elsewhere, but if they cannot be addressed on site, you look off site. We can agree about all of that.
Yeah, I mean, this goes back to what I said yesterday in terms of, the LNRS are supplementary to the biodiversity gain, that they ultimately aim to achieve the same thing. LNRS is a tool to achieving that biodiversity gain. So it has to be seeing, okay, where can you, if you can't deliver on site in terms of the biodiversity gain, which we can't do, how can you improve that biodiversity in the best places? And that's what I take, the mapping information, whether it's the extract you provide or the wider, which shows other areas where there is areas which can be enhanced or will achieve positive aims, can be tied together. So it's a tool to be assessed in the round.
I was almost with you until that in the round bit, but I think you agree with the approach that I said that the guidance requires, which is that it's on site unless that cannot be done, because you say it can't be done here. That was part of your answer.
Yeah, I mean, this goes the link between the biodiversity and net gain. Obviously, there's a requirement to achieve at least 10%. We achieve more than that. The site, for the proposed event, can be achieved. Therefore, you look at off-site. And the point I make is, at this wider extract, a large chunk of the site isn't any of the grassland or woodland identifications, whereas actually most areas of the countryside, to one degree or another, is identified with an enhancement. It's a very broad tool.
So I didn't want to interrupt you. How have you come to that conclusion? Is that by looking at the mapping that we have available and noting that some of the site is in the white area?
Yes.
Right. We can check, and you may already have checked, but isn't that a consequence of the fact that it's just in an adjacent focus area?
I don't know why the line's drawn like whether that's something to do with the plantation. I don't know.
No. Okay. But that being as it may, we've got the focus area, we know what it says, and the reason that you say it can't be done on the site has to be assessed, bearing in mind, first of all, no active consideration was given to this specific question in accordance with the statutory guidance, and secondly, that is in effect a self-imposed fetter, because the reason the problem exists is because of the level of development that your clients are seeking to bring forward on the site.
Taking a step back in all this, we agree this is, the final form of the LNS that's been published is a material consideration as one of many, and that has to be balanced against all the other competing objectives. I would say, whilst it is material, there's other more competing aims.
Well, we'll come on to that if it's a general point about planning
it's not
balance.
a general comment in the sense that the guidance says what it says. It doesn't stipulate it has to be on site. I think we agreed there. But the aim is to enhance the local nature recovery strategies in terms of, can we enhance that? Well, we can, because we've got these 3 off-site locations. So it's, in my view, met. That always comes back to whether it's a matter of the golden rules or not. We disagree on that view. But that's, so actually, however you get to it, this box is effectively being ticked.
Without any analysis of the actual guidance, it's been ticked as a matter of happy coincidence because there is BNG provision being made.
Well, it's BNG provision, but it's the type of BNG provision.
Well, in the gorse, I mean, there's not going to be much ability to improve neutral grassland in the gorse, is there?
No, but that's not where we're doing the grassland. That's the woodland. It's the arable parcel 2 is where the grassland enhancement.
Now, I want to move on to different topic, and that is the topic of local context. There's been a lot of landscape evidence about this, and I'm not going to trespass onto that, but what I am going to ask you to just recognise and confirm is that the local context has been recognised within the development plan itself, and in particular within the Radlett neighbourhood plan. So if we turn up CD 3.7, you let me know, Mr. Allen, when you're there.
Okay, I'm at the plan, yeah.
Thank you. And so if you move on to look at the objectives of the plan, we can see those discussed early on within the plan.
So what page are you?
Page 25. I'm old school, I'm afraid. I've got a hard copy, so I'm using the pages in the bottom corners.
Yes.
So objective number 1, to protect and enhance the verdant character of Radlett. So without necessarily giving these any specific priority, it's perhaps interesting that it appears as the first objective of this neighbourhood plan, which is now part of the adopted development plan. We can agree about that, can't we?
Yes, it's part of the development plan, yes.
And then if we move forward to see, I mean, the inspector may have had an opportunity to peruse this document, he'll see it's replete with references of a similar kind. But if we move forward to the way that the policies operate and the way that they're informed by policy intent, if you look at page 39, you can see there policy intent to protect and enhance the verdant character of Radlett whilst meeting housing demand, and we can see what HD3 requires in terms of respecting and enhancing local townscape and landscape character and patterns. So we have all of that within a locally adopted provision. And if we look, just to take one more example, if we go back ever so slightly and look at page 32, we can see at paragraphs 3.37, 3.38, part of the reason why that policy is there and recognised as being important locally. 3.38, one of the key aspects residents love about our village is its verdant nature, with its many residential streets framed by grass verges, green hedges and mature trees.
Yeah.
So the requirements of HD3 include, don't they, the need to both reflect and respond positively to both local townscape and landscape character.
Yes.
Yeah, we can agree about that. That's part of the test the inspector needs to apply to the landscape evidence that he's got in this proposal. Now, in relation to that, I said I'm not going to trespass on the detail, and I won't, but in broad terms, this development is open to the criticism that having been located at a settlement edge near to relatively low density and verdant areas of Radlett, what it would do is ramp up the level of density and the form of development on that sensitive edge of Radlett.
Well, I mean, it would, the density would be higher, but, you know, as, I mean, this policy was in place the last appeal, and Inspector Fagan found no, that policy hadn't been breached.
No, he had other compelling reasons for finding against you. It wasn't really necessary for him to go there.
But not quite, but that policy was there. It said what it does. it was considered by Inspector Fagan and found no harm. Whether he obviously dismissed it for other reasons, but that's by the by.
Yeah. Okay. Now, one of the consequences of what's happening there, and it's not just a modest increase in density, and one accepts that density can't be used as determinative, it can be recognised as a cruel tool sometimes, but it's not irrelevant, is it? So it's something you can have a look at. And you can have a look at, in broad terms, what the magnitude of change is. And here we're talking about, I think it's in the order of a tripling of the density of Radlett measured as a whole, and we know, because the inspectors walked it, if you look at this area of Radlett, in fact, it's a relatively low density part of the town.
It's a change in density to the immediate residential area, but as Ms Brockhurst and as he alluded to, density is just one metric.
I accept that.
And I maintain a view that with the parameter plan, there's a capability of delivering a high quality development that accords with the design policies. I don't think that's a controversial position to take.
If we look at the local townscape around there, Williams Way is part of that, isn't it? And the way that is dispersed, the form that takes, and Baggott's Close as well in relation to the bungalows. And if we look at the bungalows, the Radlett bungalows within the neighbourhood plan, you can see that at page 45.
Yep.
And so what we can see here in relation to those groups of the bungalows that are in close proximity to the appeal site, we have group 9, don't we? If we look at inset map 1.
Green. Is that green? Sorry, is it? I can't. Hang on.
Do you need to blow it up a little?
Yeah.
Yeah.
The group 9.
Group 9, yep.
Yeah.
And then we have green, which is group 3. And we
Yep.
have the, I suppose in digital terms you call it cyan, group 2.
Yes.
Thank you. All within, we can agree, reasonable proximity to the site around Williams Way and the Close.
Yes, I mean only group 3 actually border the site, intervening built form on the other two groups.
Yep. And we see at HD 7.1 the nature of the requirement there in terms of contributing positively to local townscape character, protect and enhance the contribution that the bungalows make in that respect.
Yeah, which is, I mean, I'd note that the open space is immediately adjacent to that green hatched area, which will contribute to that.
Yeah. Okay. Well, the inspector can take a view at assessing the landscape evidence as to the overall impact of these things. Lastly, in relation to the neighbourhood plan, and just to note it on page 63, we have policy GA1 dealing with movement around Radlett. And again, as you know, one of the criticisms of this scheme in terms of what it has not really taken cognizance of, what it has not fully or even really at all sought to address, are those opportunities that are identified in the neighbourhood plan and elsewhere in relation to footpaths and cycleways, as Miss Brown in her evidence explained. And so we leave the inspector to consider what we will suggest is a failure in that respect as well.
Well, I mean, on that point, I'm assuming you're looking at. I'm looking on page, as policy GA1, page 63.
63.
And
yep.
inset 2. So
Yes.
that, I assume that's what's been discussed. So it's got an
Indeed.
illustrative blue line from Theobald Street to Shenley Hill and then across to Williams Way. Well, the scheme provides that new connection between Theobald Street, Shenley Road.
But not to the footpath.
Well, well, it does, because the footpath runs along Shenley Hill at that point. Now, it doesn't specifically at the point in which the blue line touched, but that's beyond our own, or the red line. So actually, how I read this policy is the objective is providing that link, whether it exactly follows. I mean, it's just a squiggly line, so I don't see how you could say that it has to follow that exact alignment. It's a closed site, so we are facilitating that connection, which goes back to why I attach some weight to or additional weight to that connectivity as an enhancement, because we've got the bus stop enhancements and then Theobald Street footway enhancements, but we've also got this providing this new connection. So in my view, we accord with that policy objective of the neighbourhood plan.
All right. An area of disagreement between us there, and Dr. Bowes has his answer. Now, turning topics to the local plan and the evolution of the local plan. 3 relatively simple points, hopefully, about this. First of all, you accept, this is a matter of record, that the appeal site does not feature in the revised spring 2024 regulation 18 version of the plan.
No.
And that is, insofar as we have any local plan before this inquiry, that's the most recent version that was generated, but it's no longer relied upon.
Yes.
Thank you. Second, the local development scheme confirms the intention of the local planning authority to meet the December 2026 submission, and the inspector knows why that's an important date. You know why that's an important date. Local planning authorities up and down the country are currently scrambling to get themselves ready for that date because of its importance in terms of if it's not met.
Yeah.
So it is fair to assume, isn't it, that this authority, like a number of others, will now be doing everything that they can do to bring the plan forward by that stage.
Oh, yes, but there's not a lot of evidence there is.
No, but we acknowledge the importance of that date, which has not been there, as it were, beforehand.
No,
certainly not in certain terms.
Yeah, no, I don't, that date is important, and as you say, a number of authorities are progressing. But I'd say Hertsmere, given that draft iteration was a couple of years ago now, which was only a very draft, there's a hell of a lot of work to be done in a very short space of time. I remain unconvinced that they will meet that.
Now, as the plan moves forward towards that deadline, there will be consideration of things like grey belt land and how that's factored into this planning process. And so, as is often the way in relation to green belt authorities, as a plan moves closer towards adoption, so there is a prospect of further planning applications coming forward on the basis that there are draft allocations which are supported by the local plan.
As a principle.
Yeah, thank you. Now, as we know, this site is not currently supported, and in relation to that, the observation that might be made is that the 2021 plan was a Regulation 18 plan. So this site, in terms of how it might or might not have been supported by the local authorities, never been supported at Regulation 19 stage.
No.
Never been supported at Regulation 22 stage before submission to the inspector.
No.
Yep. And other sites have been identified, and indeed sites were identified in that Regulation 18 because, as you know, there's no obligation to actually identify sites in a Regulation 18 draft. You can do, you don't have to. This one did in 2021 and in 2024. And the benefit of that is that it allows public consultation and informed views to be given about the benefits or disbenefits of a particular site. That's what happened in relation to this site, and then it dropped out in 2024.
Well, yeah. I mean, that's a point of fact. It did. I'll go back to my evidence. Is that was a point in time then, and made, in my view, on the basis of the public objection. The 24 plan, in terms, didn't accepted that it didn't meet the need that was at that time. That need is only increased, even increased over and above that at the 21 plan. So I think you can draw, because it's only a Reg 18 plan in the first place, and it is only a list of sites effectively, which further reduces the sort of weight you can take from that. But the fact is, any new local plan coming forward is going to have to do a lot more heavy lifting when it comes to allocating sites. And given the background to the site and the fact that it was a draft allocation in the 21 plan, and for the reasons I set out, I'm of the firm view that it will be a proposed allocation.
All right, well, we can explore that a little bit further, but not too much, because, as we know, the plan-making process is still at a relatively early stage. But if we look at the way that the authority approached this, and we look at CD 3.4, and that's the 2024 version of the Regulation 18, and if you look at first of all at the plan of Radlett, which I think, again, those using electronic documents will forgive me, it's page 60 in the manuscript.
Yeah.
Now, just before we get on to what this plan shows, it's not unusual, is it, even in today's day and age, for heavily constrained authorities where there is a lot of greenbelt land, as one example, to put forward local plans that don't meet the housing requirement.
Yes, that is the case. I mean, interesting. Yesterday they were holding direction to 3 years who are doing that approach, but that's a separate matter in terms of if there's evidence to justify that. But Greenbelt alone, they have to at least look at this. They can't just say it's Greenbelt, no, therefore that's a constraint per se.
We agree, Mr. Allen. I agree they're going to have to look at it, and nothing between us there. Let's have a look at page 60. Radlett, we can see what was being done in 2014, and I'm simply going to invite you to cast an eye as an experienced planner over that and say that there is, with the exception of Hell 180, which is removed from Radlett as a town, everything that is happening here in terms of around the site boundary is consistent with rounding off development. In particular, the triangle in HEL 214.
Yeah. So those allocations are effectively rounding off. Is your point in terms of?
You can see they're consistent with that. You wouldn't describe any one of those as being an incongruous addition, would you?
Well, no, they're all related to the urban area. So
thank you. And we can see the discussion of site HEL 214.
I don't think necessarily that was necessarily a factor in. Well, I don't know. I don't think it's necessarily a factor of those sites being proposed for allocation. I'm not sure it says anywhere that that's the justification for it.
Yeah. Again, you can take a broader view by looking at page 12, which is the proposed housing and employment sites overall. And again, if you were to look at that in a similar way, certainly in relation to Radlett, you might form that view about there being rounding off of the settlement, but no more in reality. As I say, plan making process in the early stage, so we don't want to spend too much time on it, just trying to cover some ground that wasn't necessarily trespassed on yesterday. And when we look at the parts of the evidence base that the appellant has relied upon that feed into that, I mean, the first thing that we need to recognise is that the judgments based on that evidence base, and I'm talking about the LUC materials of September and October 2020, did not actually result in the allocation of the land in the most recent iteration of the local plan we've had, because we've seen that. So that was the consequence of those documents being analysed together with other parts of the evidence base.
Well, I mean, it turned, like I say, it's for what reason why the site fell out. Clearly the LUC work was published 2020, it was proposed for allocation in the 21 plan, therefore there must be a direct link, that justification for it. Now, the 21 plan was consulted on, 18,000 objections, they changed their approach. To what degree that was influenced or not by piece of the evidence base, I personally view, I don't think it was, but it's not quantified or stated anywhere.
Well, yeah, and you're not referring to any particular document to make that generalised allegation good, are you? No, right, okay. So let's look very quickly then at the LUC materials. We have the landscape sensitivity assessment, which is the first one, September 2020. And just to make the point, I'm not even sure we need to turn the page up, but it's with LUC's helpful pagination system. It's A59.
So what document is this?
So this is CD 4.7.
4.7. Yeah. Yes.
And it's the map showing the designations at that stage and 21B. And just to make the obvious point about... Sorry, are you there, Mr. Allen?
Yeah, so what plan, what page? Sorry,
A59.
A59.
I always struggle with the LUC pagination.
A59. Oh, yeah. Yes, I'm there. Yeah.
So it's 21B at that stage that we're looking at in terms of designation, and it's just to make the point about just how broad that area is.
Yeah.
Yeah, so there's nothing that's really assisting with a detailed examination of the site within that material, is there?
It's a wide site. Well, 21B is wide, yeah.
Exactly. And then if we turn to the outline landscape appraisals of October 2020, so that's CD 4.8.
Yeah.
And again, what we see there, and the Rule 6 parties witnesses dealt with this, that there's no particular narrative within that in terms of the support for a specific proposal for 195. First of all, we can agree about that.
Yeah, no,
And secondly, we can agree, can't we, if we turn on to the second page of that, on page 63, there are some decision aiding questions. And towards the bottom, do you see the one, how would development of the site affect settlement pattern and separation?
So how, yeah, okay. So yes, so third to last one, yeah.
Yes. At that stage, the view the authority was taking is the site does not play a role in separation of key settlements. Now, that is consistent with what was being suggested in front of Inspector Fagan, but of course he didn't accept that approach in terms of Radlett being both a town and, in fact, a large built-up area. So, insofar as there were to be any reliance on that, the position has clearly changed in terms of the views that have been expressed. Yeah?
Yeah, I mean, I guess it's the context in which this is being, this is not obviously looking at from a national policy grounds, but presumably from a landscape character perspective.
Yeah, and just to rehearse very, very quickly some of the points we made yesterday, obvious points about chronologically this kind of analysis cannot have taken into account the PPG guidance in relation to grey belt and so on. Right. Now, we don't need to spend time on the ARAC materials because Mr. Cosgrove dealt with those yesterday, and I think there was a measure of agreement between you as to whether or not they really reflect the criteria that the inspector has to apply now. In relation to Inspector Fagan's report, I do want to just go back to that briefly at core document 5.1. Now, one can make observations about the general importance that we say it's clear Inspector Fagan attached to this land in terms of greenbelt purposes. But if we look at paragraph 24 about the conclusion he reached on purpose B at that point in time, he says in the middle of that paragraph, I agree that it performs moderately against purpose B because there would remain open gaps between Radlett, Shenley and Borehamwood following its development, and then he carries on to deal with purpose C. Now, the guidance that we now have is more detailed than that, isn't it, in terms of the criteria to apply, and what it doesn't require, by way of example, is for there to be no open gaps between Radlett and Borehamwood. That's not what the guidance on grey belt requires in order for a strong contribution to be made.
So just repeat that question.
Yes, I'm just taking up I'm taking up the logic that Inspector Fagan used at this stage, and we can see that he gave a summary conclusion for his response in relation to purpose B, first of all. We see that recorded. Secondly, you and I agree that there is now far more detailed guidance in relation to the PPG grey belt test that this inspector will need to apply. We agree about that.
Yeah.
And thirdly, we agree, don't we, that it is no requirement, even in the illustrative features of that guidance, that there should be no open gap between the two settlements before any parcel of land can make a strong contribution. We agree about all of those things.
So the no open
Yeah, there doesn't have to be physical merger of two settlements before you can say that that parcel of land is... You're nodding, you agree with me. Thank you. Good. Just the way it was put to some of the witnesses, one might have been forgiven for thinking that that was a case that might be advanced. Now, so when we look at the way that Inspector Fagan approached this overall, what we do know is that he had a concern that the development of this site in relation to the purposes that he had to consider would be such that if it were allowed, it would render the national policy of green belts potentially ineffective if this kind of approach were allowed, in the same way that the Lancaster inspector considered that development of the kind that was in prospect there might have had a similar effect on national policy. And those are important things for this inspector to bear in mind, aren't they?
So we're talking in the context of Purpose B, or was it general?
Yes, well, Purpose A and Purpose B.
I mean, it's open land, there's development there. There needs to be assessed against national guidance, including PBG, on its role to greenbelt purposes and reaching a view. So that's the approach that needs to be taken, having regard to the considerations.
Thank you. And what we shouldn't be doing is waiting until a point in time where the next developer comes along and says, well, don't worry about the coalescence of towns because it's substantially already occurred. The purpose of the green belt has been defeated in that respect.
Well, no, I mean...
That would be counterproductive.
What has to be assessed is the site, the scheme proposals on the site in isolation. You know, what might happen elsewhere, but it's in terms of what is the circumstances now, gap, etc., based on the scheme proposals.
Thank you. Now, in relation to the way that Inspector Fagan approached a few matters, we have the judgment that Mr. Justice Holgate, as he then was, gave in the Fairfax case. So can you turn that up for me? I think that's CD 5.8. And let me know when you've got that.
Yeah.
Now, first of all, in terms of the overall approach that Inspector Fagan took, Mr. Cosgrove took you to paragraph 103 of his decision letter yesterday, the point where he makes the point that essentially, in his judgment, this was not a close run thing. You could have modified and given greater benefit to two or more of the benefits that he identified, and the appeal still would have been dismissed. So it wasn't a fine balance of judgment. It simply wasn't a close run thing in his judgment.
In his judgment, based on circumstances at that time, I mean, it's quite clear what he says.
Thank you. Not a close run thing. Paragraph 126.
Well, I wouldn't... that terminology, I mean, I think it was, he's clearly saying that even if he attached differences to some of the weights, his view wouldn't change. That's what I simply draw from that.
Yeah. That led in the High Court to what happened and what the judge recorded at paragraph 126 of the judgment on page 28. And that was that two grounds that were being pursued were ultimately at the hearing not continued with, because even had the inspector reached different conclusions, he would have inevitably dismissed the appeal. And so that's how Mr. Justice Holgate read the decision letter as well.
Yeah.
Yep.
Yeah, I mean, that's clear record, This becomes relevant only, our main argument case is grey belt. So all these factors becomes largely moot. If the inspector agrees it's grey belt.
Well, let's pause for a second. And you're saying these arguments are largely moot. There's a second limb to this case that may very well be important about inappropriate development in very special circumstances.
Yes.
Mr. Allen, are you getting to the point where you're prepared to realistically concede that if we reach that point, in light of what Inspector Fagan has said, in light of what we can see in the judgment of the High Court, that this scheme has not changed? We've been round that block. No. It should fail.
Absolutely not. That's not what I'm saying. The point I made is this was, of course, in the context of a VSC case, the previous appeal. This time, there's two strands to it. That's the point I'm making. And our position is it's grey belt, therefore you don't need to entertain VSC. But I accept we've obviously won that case. That is that is a limb, so it's proper to consider. So that's the point I'm making. And as I said yesterday, there are a number of factors that have changed since the previous appeal was determined in terms of the weighting and so forth. That, in my view, that is entirely logical and possible to come to a different conclusion and justified to come to a different conclusion than Inspector Fagan.
And we've reminded ourselves of the approach that Inspector Fagan took. We've seen how that was approached by Mr. Justice Holgate, albeit any challenge, of course, had to be based on an error of law rather than anything else. We've spoken about the revision or otherwise to the scheme, and in that respect I want to come back quickly to the Police Services advice of the 27th of February 2025, so recent advice given in the context of this application. That's CD 4.13.
Yes.
And we can see the discussion that takes place under the heading on the second page, review of submitted documents, and amongst other things they looked at the LVIA, they looked at the parameter plans, which we can see from the foot of the third page of the letter. We consider these to be inappropriate on the edge of the settlement for the reasons that they give. And then, as I asked other witnesses about, we have the conclusion and the 5 steps that Police Services said in their advice should be taken. None of them substantially addressed. We've already agreed that in the evidence. And when you look at what is being discussed here, the terms in which the expert advisors were commenting on this scheme was to note, first of all, in the conclusions, minimal mitigation proposed to reduce landscape and visual impact. So that was their advice. We expect design to respond proactively to our previous consultation. We've looked at the neighbourhood plan policies and other things that require respect and positive contributions in that relation. Look at Inspector Fagan's conclusions. They invited consideration of that. And then the 5 specific elements drawing on all of that: greater landscape boundary buffers to better assimilate development, improved green infrastructure throughout, indicative plan to provide illustrative layout improvements, so layout was an issue as well as far as they were concerned, and the point about pedestrian permeability. Now, if one looks at what's being discussed there against the parameter plans that the advisors also looked at, and they obviously knew that they were commenting on a scheme in outline, what this is indicative of is what the landscape witnesses for the LPA and the Rule 6 party have recognised, which is this is a scheme that, even though it's in outline, doesn't need tinkering around the edges. It needs an overhaul.
Well, no, I don't. I disagree with that position. I mean, as you say, outline, reserve matters. I'm of view that actually a detailed design that is capable of addressing, at least in part, some of those concerns is capable. The scheme, largely as was Inspector Fagan's assessment, and he didn't reach that conclusion either. There was a slight amendment to the parameter plan in terms of extending the buffer slightly across Shenley Hill, so there was some change, albeit it was relatively limited. But like I say, for the reason that the detail that comes can address those issues, and it's clearly a view that planning officers took when assessing this application before it went to committee. So no, I don't agree with the assertion.
Thank you. Now, finally, I just want to ask you a couple of questions about weightings. And I'm, again, not going to trespass, I hope, on anything that was discussed yesterday. But I want to take you back to the Fairfax case. So if you open that up again, 5.8. And if you've got that, in the opening observations that Mr. Justice Holgate made when he was characterising the grounds of challenge and the fact that there was a challenge in the Fairfax case to certain weightings that Inspector Fagan had adopted, you can see the observation that he made in paragraph 11 on page 5. Just take a moment to remind yourself of that, because it's a long judgment. You may not have looked at all of it recently. But in the second half of that paragraph, he says the inspector gave moderate or neutral weight to 2 benefits in the Vistry appeal, limited weight to 2 benefits in the Fairfax appeal. Second, the decisions attached much greater weight to other self-evidently important subjects, such as harm to the green belt or the provision of affordable housing. And that's not an objectionable approach for the judge to have taken, is it? There are certain factors in these kinds of cases that will tend to have a greater elevation than others, and he's identified the 2 that really apply here.
Yeah, I mean, yes, that's a reasonable view.
Right, thank you. And so in that respect, we have all of the greenbelt harms that have been identified and that we don't need to trespass on. And in the other side of that scale, we have the provision of market housing and affordable housing in broadly the same ratios. There's been a slight change, but insofar as it was before Inspector Fagan.
Or quantums.
Yes. Yeah. So he did that exercise at that point in time. Now, you have relied upon the position more recently. You say there's a deterioration there, but on any view, it is clear that Inspector Fagan recognised that there was highly unlikely to be improvement, and indeed likely to be a continuing problem in the future, didn't he? And you can see the judge read his decision in that way. You can find that, page 18, paragraph 76. So just take a moment to read that. So Inspector Fagan wasn't approaching his decision on the basis that there was a good prospect that there would be some near-term change in the position, or even that it wouldn't be continuing to deteriorate because there was no prospect of a local plan, for example, coming forward.
Yeah, no,
that's fair, isn't it?
That's fair, but
Yeah.
I'll go back to what I said in terms of there's a deterioration and then there's what's happened in Hartsmere, and that's, in my view, far more than that. I mean, it's chronic. So whilst there might be a principle there, I think you've got to look on the facts on the ground now compared to when it was, even with Inspector Fagan's comments on that respect. And also, you know, draw reference to other appeal decisions that have been determined in the borough since, and all of them have attached a very top weight.
Yeah, I wondered if you were going to do that, because that's my next question. One has to be very, very careful about that kind of analysis, don't we? Here we have actually the benefit of Inspector Fagan, who considered this site against the appropriate policy context, apart from Grey Belt, did it relatively recently, looked at all of the considerations under your scheme. So we've got that. It's, as has been said by other people, a potentially very helpful blueprint in that respect. When you look at other sites dealing with other circumstances, other inspectors dealing with their own way of weighing things, one has to be particularly careful, and that is something that Mr. Justice Holgate identified in terms, let's look at it, page 34, paragraph 160. And this is a comment that is specific to weights that are given in other cases. So it's not the same as dealing with qualities about judgment, incongruous development that you might find in Marlowe. This is a specific point about how the application of weighting should not without real caution, be borrowed from one decision to another. And you're not going to disagree with Mr. Justice Holgate.
I can see that, but I mean, I think that seems to be in the context of a BNG, which was a more of a specific matter. These are matters of general, housing supply numbers. I don't, yes, each site is on its own merits, and therefore there's going to be differences, which has to be a factor in how you apply that. But I'm not talking about a specific site or the characteristics of a specific site. I don't know in terms of those other appeal decisions. But what they did consider is housing supply numerically. So that is a point of principle that is the same irrespective of where the specific site is in that authority.
Yes, but the weight that's given to housing can be reflected in the particular scheme that's being brought forward. It can be reflected in the particular scale that an inspector uses, all those kinds of things.
Yeah.
I'm waiting, and you agree, I'm waiting for the advocate who's brave enough to say to Mr. Justice Holgate, well, when you made that observation in paragraph 160, it was only in relation to biodiversity net gain, wasn't it, my lord?
Well, no, but I only say that because that's what the specific reference is. But, as I say, it's a point of principle on the housing numbers. There's a difference to it. But, the inspector will come to his own view on that point.
Mr. Allen, thank you very much.
I'll just have a short break before re-examination. If that's okay, if we can come back just at 10 to 11, please. Thank you. We'll adjourn there. Thank you. That's 10:50. You can resume the inquiry now. Mr. Baglin, I assume that was the end of your examination. Thank you. I see rather quickly otherwise. Thank you. And Dr. Bowes, re-examination?
If I may, just three short points, please, sir, just some clear up a point or two. Good morning, Mr. Allen. So the first one is about events of this morning. And if you could take up, please, core document 3.4, where my only friend, Mr. Beglin, took you. This was all about the 2024 consultation. And within that, if you could turn to PDF page 63, printed page 65. Should be.
Yep.
Site 1029 Radlett, is that what you've got? Great.
Yes.
And do you remember you were asked some questions about the draft consultation, and it was put to you that really that these were sites which were primarily rounding off. Do you remember that line of questioning?
Yes.
Yeah. I couldn't resist this. If you have a look at the site description for this Radlett site, can you just cast your eye over that short box, please? Just let me know when you've finished.
Yes.
So even in the latest site selection criteria for consultations on sites in this borough and in Radlett specifically, is the council placing any weight on the presence or otherwise of woodland and wooded areas in sites which might be appropriate?
Yes, you can see that in the last sentence.
Thank you. So that's today's event. Second point of three, yesterday afternoon. My learned friend Mr. Cosgrove asked you some questions about your evidence that you considered the judgments that have been reached on the performance of this site against Greenbelt not to be reasonable. And you said, well, I don't think that it was reasonable to come to the judgment that this site performs strongly against purposes A and B, and you were asked some questions about that. Do you remember that line of cross-examination?
Yes.
And it was put to you that your judgment in that respect was at odds or adrift from what Miss Brockhurst had said, because she had given evidence that the judgments reached weren't ones she agreed with, but that they were reasonable. Do you remember that?
Yes.
I just wanted to give you an opportunity to make sure you've got what Miss Brockhurst said and her evidence in re-examination, which was that she did indeed say that she agreed that the judgment that one might perceive the two settlements, Radlett and Boreham Wood, as having moved closer together as being reasonable, but she did not think it was reasonable to say that they had actually or perceptually merged. That's her evidence in re-examination. Are you in fact saying anything consistent or inconsistent with what Miss Brockhurst is saying?
I'm not saying anything inconsistent with that.
Okay, that's point two. And final point, just about Inspector Fagan's decision. Probably know it off by heart by now, but if we need to go there, we can. And it was simply this: it's that you were taken by my learned friend, Mr. Cosgrove, to your judgment that the appeal site is subject to urban influences. You say that in your proof, and you said it orally. You gave evidence about that. And my learned friend cross-examined you about that and said, oh, well, now Mr. Fagan found that the site wasn't, in fact, particularly influenced by the urban area. Do you remember that?
Yes.
He took you properly to the relevant parts of the decision letter. Now, I just want to ask you, if this inspector were to accept what Inspector Fagan said about urban influences and all the rest of it, what was, in fact, Inspector Fagan's ultimate conclusion about the performance of this site against purpose A and B?
Moderate.
Yeah. Thank you very much indeed, Mr. Allen. Thank you, sir. Those are my only questions in re-examination.
Thank you. If we can now move on to the round table session in respect of conditions and obligations. I'm happy with that. Now we'll get
Just before we do so, forgive me, I was just getting my reference together. May I ask you a question about a particular piece of evidence that was, or a request or query about a piece of evidence that was raised this morning, and that was a factual question that was raised that Mr. Allen didn't know the answer to. Do you remember when Mr. Beglam was asking you about the felling and thinning in response to the 2023 licence? Mr. Allen was asked whether he knew this licence, the one that's finished, the one that was being cross-examined on, whether all of that had taken place, you know, the 30% and the volume and so on, and Mr. Allen didn't know. I'm not suggesting it's necessary, I'm not seeking to put it in. It's a factual point, though, which I am sure we could clarify and have put in front of you in the inquiry in an email response if you felt it was helpful.
What form, essentially, do you get a discharge from the Forestry Commission? What nature does that take?
I think it's the estate confirming what it has done. Yeah, because obviously on instructions we've said, and I've said so to you, that the licence has been complete, exhausted or completed or whatever you want to say. So I think the point was raised, well, I think Mr. Allen said you go there and you can see the trees, and the point was being raised, well, has it all been done though, all of the things that are allowed for in the licence? I think that's the point that was being put. And I don't know, I'm not suggesting there's anything that really turns on this, but if you'd like it, we can have that confirmed one way or the other for you.
I'm quite happy without that particular piece of evidence. Mr. Beglam, do you have any view?
So I think I do. If it's something that's coming from a regulatory agency, so it's a discharge or something of that nature, then we wouldn't object to that. I think what one should be wary of at this stage in the proceedings is the introduction of new factual evidence that is essentially coming from, for example, an owner of land that is not something that is directly supported by communication from regulatory agencies. So I'd have no objection to the former category case, but in relation to the latter, I think I would have a reservation.
Mr. Cosgrove, any particular views?
No. Keep out of this one, thank you, sir.
Thank you. I'm quite happy to leave it as where we are on the evidence now.
There's a joke about the wood for the trees and them. I'm not going to make it, sir. Thank you. No, understood. We'll leave it. I just thought I'd offer, since it was a factual
appreciate it.
Thank you very much.
And actually, the only other point that we very briefly mentioned was inquiry document list, and had been suggesting you put your heads together to produce a particular list. Otherwise, I have my own particular one, but I don't necessarily want there to be a divergence with others of any document list. I know I received, and it should be circulated by now, essentially the submissions from the interested parties, local residents, the speeches that they read out. That should be making its way from my case officer to yourselves, just they would be included as well. So do you want to do a formal list for me, or are you quite happy for me just to have my own? I presume you haven't done one yet.
No, we haven't.
Fine.
There haven't been very many. That's one of the reasons why we haven't done it.
There hasn't been a great number, so I'm quite happy with what I've got.
The number, I think, so there was the number of speakers, I think the way that was dealt with was to electronically send you that, so obviously we don't know which order they came in or how they've been done. I think it probably would be useful for the parties at some stage to agree a list, so, but I don't think it's essential immediately now.
I agree with that. If you'd like us to, we will. So
okay.
I don't think I don't know whether any of us...
You can prepare a list for me and submit that.
Fine,
we'll do that. Thank you. We'll sort that. Fine. So if we turn to look at the unilateral undertaking, I understand it has been prepared.
Yes, are you okay to use your mic up there, Emma? Could I introduce our solicitor, Miss Hargreaves, Emma? I don't think we put Miss Hargreaves on our appearances sheet, did we? We'll send an email to the case officer, so with the full details on, but it's Miss Hargreaves, Emma Hargreaves of Pinsent Masons, who is sitting, you might be able to identify which of our team she is. In our heavily gender-balanced appearance before you at this inquiry. Miss Hargreaves is behind me, and she's the author of the note and has been dealing with the 106.
Okay, thank you.
So, if I may, for our part, I'm going to hand over largely to Mrs. Scott for conditions in section 106.
And likewise, Mr. Stroud for the council, sir, on those. Thank you.
Thank you. So as I stand at this note, it's essentially one I've had before, but updated to yesterday to reflect the conversations we've had with the county council in respect to primarily the education land. Is that correct? Yeah. Yeah. Sorry, as you're making your way back. Mr. Hargreaves, thank you.
Sir,
Yes.
I'm not quite sure if we're talking about the conditions now or the obligations. It's a bit difficult to hear just the side-to-side conversations, but my name is Tim Morris and I was here for the conditions part, and I'm sorry I wasn't quite clear which one we were talking about at this time.
So yes, this is the roundtable session of conditions planning obligations undertaken without any prejudice for any parties. Doesn't suggest I've made up my mind. And currently we're just looking at the unilateral undertaking.
Okay, and I'll come back
And we'll come
about
on
the
to
conditions. I
conditions.
believe you've had a message from Mrs. Bell about, if I can say, my name's Tim Morris. Mrs. Bell, I think, has passed a message from Councillor Gillingham asking if I could be substituted as she's indisposed for the conditions discussion. Okay. But I just wasn't sure whether it was the obligations or conditions. It was just a bit difficult here. Thank you.
No problem. So, Ms. Hargreaves, do you want to talk us through this note initially?
Yeah.
Thank you.
Yeah, that's fine. So the general approach is a unilateral undertaking. We took this approach because that was the approach previously taken on the last appeal. So these are obligations given by the landowner and Fairfax as applicant to both the Borough Council and County Council. So the land bound is the owner's freehold, and the title reference is there. That's been agreed with both the Borough Council and the County Council, and the applicant is party given their interest with the promotion agreement. So those points have all been agreed. The obligations within the unilateral undertaking are set out within the table. Everything has now been agreed with both the Borough Council and County Council. So I don't know if you want a hard copy of the UU as well. We have one. Yeah, that's fine.
Yes,
so at the front end, we have the usual boilerplate. Would you like a copy? We have the usual boilerplate provisions, so I won't take you through those unless there is anything.
So you just want to take me through the summary of provision?
Yeah,
what
of course.
that's actually included, thank you.
So the first is Schedule 1, affordable housing. That secures the 50% of on-site affordable housing. The tenure split is consistent with HBC's local plan. So 75% is split between 50% affordable rented housing, 50% social rented housing, and the remaining 25% is intermediate housing. The next schedule...
Sorry, I'll pause you there. Mr. Scott, the other day you mentioned some comments on the affordability or the cost of property in the area. So, as I understand it, you're not suggesting this isn't policy compliant, or it should be provided in some other way, were you?
No, I mean, it is policy compliant, yes.
Thank you. Sorry to interrupt. Thank you.
Yeah. So we have used definitions from the MPPF as well, just to ensure that it is. The second schedule deals with transfer of the expansion space, which has been agreed. So that's a 0.65 hectares of expansion space for a primary school. And there is a plan within the UU as well, which is indicative and shows where that expansion space will be. So that is subject to an agreed specification, and will include direct access from a highway of an adoptable standard. The expansion space is reserved for a period of 10 years from commencement of development. If the County Council determines that it's no longer required, either during the reservation period or does not submit a notification that it intends to use the space, that's when the owner's released from the obligation, but that's after the 10-year period. Where the County Council does require the land, then there is a draft transfer agreement already. And that's in one of the schedules. So this was agreed previously on the last appeal, and it was felt that having the transfer agreement just provided a bit more certainty what would be in there. So that's agreed with the County Council. The third schedule is a transfer of the healthcare facility land.
Sorry, just pausing on that.
Yeah.
So essentially, if it's not taken up within the 10 years, the reservation essentially ends.
Yeah.
And monies that were the primary education contribution that was reduced
Yes.
to the value of this land is then essentially repaid by the appellant.
Exactly.
Then what happens to that land essentially is back to the
That goes
the
back
owners
to the owner.
to do with as
Yeah,
they
yeah.
are able to. Okay. Thank you.
So Schedule 3 is a transfer of a healthcare facility land. So again, that is reserved for a specified period. That is 5 years initially, and then it's offered to the ICB. If the ICB confirms that it does not require or does not respond, that's when the land is essentially repurposed and provided as affordable housing land. And the intention is that it is offered to the Borough Council for a further period of 1 year. If the Borough Council wishes to use the land, then that is transferred to the Borough Council for a sum of £1 and can be used as affordable housing. In the event, though, that the Borough Council confirms that it does not require the land or does not respond within the further period, then the owner's released from that obligation and can use the land for an alternative use, but obviously that's subject to planning permission or other consent.
So just in that respect, if I recall correctly from the responses in respect to the application, like the initial request had been for a commuted sum to be paid for healthcare facilities, but that has it now been essentially accepted between the parties that the provision of the land is appropriate? Have I understood that correctly?
For the healthcare?
Yes.
Yeah. Yeah, there are sums further for healthcare.
Mm-hmm.
That's later on. So there's health contributions within Schedule 7.
But in respect of the healthcare facility, the GP surgery, it had initially said we would rather have the money, and now, no, actually we are quite happy. There's no dispute in that regard.
No.
Okay, thank you.
Schedule 4, biodiversity net gain. So this secures the 20%. That's what's been agreed for this scheme. So we'd just set out the provisions there. And there is a form of cascade where the chosen site, which is a Gorse local wildlife site, is first. And then in the event that that cannot be secured, then we need agreement to for an alternative receptor site. So it just works through the cascade. And there is a monitoring fee as well that's payable to Borough Council. Yeah. So the next schedule is travel plan. This is using HCC's drafting, so it's non-contentious, it's what they'd usually accept. There's also contributions payable as well in respect of the support fee, just to assist the County Council with the monitoring. And the travel plan runs with annual reviews for a period of 5 years as well, which is quite standard. There's also a further obligation for the owner to provide a sustainable travel voucher to each first occupant of a dwelling. So I don't think there were any queries on that. Puddingstone, that's Schedule 6. So the owner must submit a detailed enhancement and management plan, which will be agreed in writing with the Borough Council. The land of the Puddingstone is also shown on a plan that's appended to the 106. The owner will then deliver the works that's set out in the approved enhancement and management plan, and then use best endeavours to secure necessary consents for undertaking those works. The reason for that, sir, is just that whilst the land is within the same ownership now, in the event that that was to change, it was agreed between the parties that that could be limited to best endeavours. And the same for management and maintenance of those works.
I'll just pause there. I'll be quite honest, Puddingstone is something relatively new to me. Yeah. It's not something that's particularly been raised a great deal in the inquiry and evidence before me. There's been a great deal of dispute between the parties, but I recall comments in writing as to whether or not the site was geological importance, whether or not that had then been subsequently dropped. And I've gone through the SIL compliance statement, and one thing I noticed was particularly absence in respect to Puddingstone. Was any policy support, planning policy support for this provision? I don't know if there are any particular comments, and I know there's no dispute around it, so I'll go into it in that level of detail, but I don't know if there's any further commentary on that provision. And I'm also slightly unsure as to exactly what.
We'll look it up. So it's obviously an RIGS, that Puddingstone bit.
Yeah.
So I think that must be referred to either expressly RIGS or by a slightly more umbrella term involving geologically important sites. So we'll track you down there. I think there almost certainly is a reference in the plan to that. We'll find it.
Thank you. Yes.
Sorry, sir, just to add, yes, I think there is a policy reference, and in respect of the SIL compliance statement that you have on borough matters, there is a reference at the start in para 1.4 which lists some of the relevant policies, one of them being CS12, enhancement of the natural environment, and I think it's that one that refers to areas of geological and geological interest in geodiversity. I think it is a bit niche, but yes, it is there. There is a hook.
No, thank you. That's most helpful. Perhaps I can just tweak that slightly.
And 187A of the framework is the other one, which specifically refers to provide decisions protecting and enhancing sites of geological value.
Thank you. Okay, Karen, thank you.
The next schedule is Schedule 7. That picks up on the health contributions which are payable to Borough Council. So there's an ambulance service contribution of just over 72,000 and a healthcare contribution of £314,818. Those have been agreed with the Borough Council. Schedule 8 is a waste service transfer station contribution. So with the County Council contributions, I should note that those are based on figures included within the appendix. It's a formula-based approach. So upon the reserved matters applications, the applicant will confirm what the units are and the sizes, and then the contribution is calculated based on that. So apologies that there is no figure, but we assume this to be £20,764. And then Schedule 9 deals with the education contributions which are agreed with the County Council. That's a primary education contribution, and as you recognised before, sir, that takes into account a deduction for the expansion space. So the deduction is £35,401. Again, this is based on a formula, but we assume the contribution for primary education to be £1,905,895. Secondary education contribution, that includes an additional sum, which is for the County Council's land cost, in the amount of £37,277. And we assume that contribution to be £1,877,228. The SEN contribution we assume to be £327,551. And then aside from that, there's a monitoring contribution both for the Borough Council and the County Council in association with their monitoring costs against the obligations in the 106. And then the appendices include the usual land ownership plan, which confirms the land against which the obligations are enforceable against. And then some of the other indicative plans which I referred to before, and other documents which are key to the obligations.
Any particular comments from anyone? No? Happy? Okay, thank you. I have looked through the document itself, and I don't have any particular concerns around the mechanisms and the like, and I don't think anybody else has raised any concerns, and that's why I'm quite happy with that. Thank you.
Thank you. So just with timings as well, the Borough Council confirmed that it needs 14 days in order to avoid risk of challenge. So the document, I understand, has now been uploaded, and we just need to make sure that there is also time for the parties to execute the document, which 14 days seems quite reasonable to do so.
Objections? It's unilateral undertaking is what you said, didn't you? Yes, it's just, yep, okay, 14 days, thank you. If we can turn then to conditions, I tend to do this by exception rather than going through the whole of the document. Mr. Morris, did you want to raise your interest in respect of particular conditions or particular issue that you wanted addressed in conditions?
It's number 14. I'd be happy to wait if you're going through them in order.
Okay. Thank you. I'll come on to 14 then. So I've just got the suggested list of conditions in the schedule. Firstly, my apologies, because as planning inspectors tend to do, we then kind of ignore the particular conditions you have in there and add our own. So in respect of reserved matters and timescales, I'd go with the PIN's default conditions in respect of those, to which leads me to ask in respect of condition. Can you hear me okay? No, different microphone. The second condition, respect of the approval reserved matters, excluding school and medical centre. To my mind, from the description of the development and the submitted plan, they are only essentially not related to physical buildings or the medical centre. They're just the reserved land, so I don't see a particular need to exclude that. And then it's whether or not you need to make particular reference to the parameters plan or just leave it as they are just reserved matters. Any particular thoughts on that from the parties?
I'm with you. So I don't think, strictly speaking, one needs to have that. Certainly that second one, because it's a requirement anyway of complying at the detailed stage with the parameters. But we're not objecting to it. But I take your point, sir. I think that's probably a bit more precise.
No, thank you. And then we have a general compliance with the plans, the parameters plan. Any particular comments on that? I mean, obviously, Mr. Beglin, we've had comments in respect of the appreciation of the density and the like, and then if it were to be approved, do you, any particular, Mr. Ryder, any particular comments on the inclusion of that particular plan requiring general compliance with that plan?
So my only comment is that the parameters plan does show 2 and 2.5 storey development. and then it only increases to 3 stories in the middle. So if you did have to increase the density to create more landscape, which you are going to have to because we now have a more buffer along Shenley Road, so the parameters, the illustrative layout didn't accord exactly with the parameters plan, with the buffer having been moved. So there will have to be an increase in density in some of the areas in order to achieve the number of houses required.
Thank you. And Mr. Warren, Dr. Bowes, any particular comment on the inclusion of that plan?
Not particularly. So, I mean, obviously the parameters plans are fixed, and we've taken the point. I know that you've seen it in our rebuttal. I think Mr. Allen's rebuttal about why the master plan isn't the same as the parameters plan. Not 100% sure, to be honest, the extent to which that tweak, if you like, will lead to a higher DPH density in the end, because that really is going to turn on what scheme comes forward at the reserve matters stage. I take the point in very general terms as a possibility, but it's difficult to know at this stage what to do with that.
And then within the framing of general compliance as well. Okay.
Yeah.
I'll consider that. Thank you. Then in respect of some of the various conditions, I'll be quite honest, but much like the surface water drainage scheme is perhaps where sometimes my methodology slightly differs from some councils, and I appreciate they like to have an awful lot of detail in the conditions, whereas I have been tempted in the past, and particularly following guidance, is to leave them actually relatively open. But I appreciate a lot of councils like to give that detail because it's the expectation of what would be submitted. So if the parties have any particular comments on that, I appreciate it references existing outline drainage strategies and the like, and the PIN standard condition would probably require the repetition and submission of that as a document. Are you happy with that considerable level of detail in that condition?
Yes, I imagine this condition will have been considered in light of comments from the LLFA. As you say, I think sometimes there can be merit in just being clear what is expected. Certainly, in this case, if the appellant is not necessarily intending to be the developer, then it gives certainty to all involved. If they pick up a permission, what's going to be required?
Yes, Mr. Stroud said what I was about to say. Thank you.
Thank you. Get through my notes. First, climate change and energy statement. I'm quite honest, I've read it a number of times. I'm still not entirely sure what I would be submitting to discharge that condition, which perhaps would open you to criticism that I commented on the detail of one condition and now I'm talking about a lack of detail in another condition. I freely admit that, but I don't know if you can give me sort of any discussion on that, Mr. Stroud, in terms of what that gets. I mean, is it sort of regarding your renewable energy generation, building techniques, like what's coming forward or what has come forward in the past in that document?
Well, I may need to return to you on this, having had may need a quick look at the development plan documents. But normally, this is an expectation that the dwellings will meet a standard. There are many ways to skin a cat, as it were. So it's not necessarily clear how those standards would be met. So there's a degree of flexibility there, but it is in order to ensure that a suitable standard will be achieved, which will be set out in the policies that are cited. Yeah.
Oh no, there's no particular objection from the appellants.
No, we're happy with that. It's quite standard these days.
Then I came to condition number 37 regarding the removal of permitted development rights, and particularly looking at the planning practice guidance that suggests that's not always going to be appropriate, necessary. Can you talk me through that?
Happy to leave that one in your hands. So I think the reasoning is given there. This is and just by way of background, the schedule of conditions. These are the ones that are in the officer report, obviously that form part of the recommendation by them. subsequently, Mr. Allen and I have gone through these, reordered them, removed some duplication following your helpful directions post CMC. I think, as I say, there is the reason is there in terms of trying to preserve openness of the green belt and preventing any further harm resulting, obviously in light of the case that the council's made and the sensitivities of the site. But if ultimately you feel that exceptional circumstances don't exist such that this condition's warranted, then of course, you don't apply it.
Yeah. Essentially, yes. So to be clear, that's suggested to be imposed because of the specific circumstances, characteristics of the site and its location within the green belt. Thank you.
We were happy to have that put in front of you. I mean, obviously, if you were, this is obviously without prejudice, but in the context of permission being granted, and if it was being granted on the basis that it was a grey belt site with no green belt impact, then you might have to consider whether it was necessary or not to have that condition, because it's a justification about restricting things in the green belt. So, query, that's the only query, but it's a footnote.
Okay, thank you. Then if we can turn back to, in particular, the likes of condition 14 and general construction management plan or construction environmental management plan. I've seen these usually added to many conditions, and it helps protect the living conditions and the like of local residents, controlling the construction process, dealing with waste, dealing with deliveries and the like. Mr. Morris, you wanted some particular comments in that respect?
Yeah, I have some documents which I bought, I think enough copies for all parties, just to help explain. It's a map, basically.
Thank you. So just looking at this, Mr. Morris, you're seeking primarily around construction traffic routing?
Yes. So
there's a weight restriction on the bridge over the railway. Is that correct?
Well, it's if you recall, Councillor Gillingham who has, I think, sent your office a message saying she's indisposed and she has authorised that I could represent the council on this specific matter. She said that while she supported the case of the Rule 6 party as a neighbouring parish council, in the event that the application was improved, they wished to present a construction traffic management condition. And in essence, and if we turn to the second page after the narrative on the first, you'll see that the map is got Shenley in the centre, and the parish of Shenley is basically surrounded by 7.5 tonne loading or stroke access restrictions. And the other factor is that the absolute weight restriction on the bridge over the railway. So Shenley is isolated in terms of construction traffic. And I think the key point is, and I'll explain a bit further, is that the parish council from Shenley would say that and I suspect Alden as well, that the road between Radlett and Shenley, Radlett Lane, is simply unsafe for construction traffic. In practical terms, perhaps if we turn to the last page where there's some photographs, it shows Radlett Lane, and I'm not sure whether you, sir, have been down Radlett Lane, but in the middle of it there's could even be a quadruple bend where the road is extremely narrow, 2.5 metres, and hopefully there's a typical tipper truck going over the middle. And if you then consider things like low loaders for excavators, it just doesn't work. And so there really is only one practical alternative route, which is on the preceding page. the solid orange line is the restricted access from the junction of Shenley Hill within Radlett and Williams Way, which is about 600 metres. And then there is the road through Williams Way and Craigswell Avenue, which you heard about from the local residents. That's really the only practical construction route to provide available access that vehicles of that size could get through. Now, the parish council wouldn't presume that they would write it, but having been published now, the amended the construction management plan draft on conditions, in the blue writing on the last page, there are some suggested words. I mean, they're not experts on writing conditions, but the core of it is the request that, as you said, for the safety of people and road users, Radlett Lane is just not suitable. Now, in fairness, that the parish council from Shenley recognised that would have an impact on residents in Shenley, and would suggest that there's some sort of time considerations as well, for two reasons. One is sort of hours of darkness and things like that, but also I think you heard on the first day of the inquiry the peak traffic around schools and other times. Now, I don't think I should go into further detail. I would leave it to your judgment or perhaps the experts in the room, but I think the key message is twofold. Number one, Radlett Lane can't be used for construction traffic access. And number two, the alternative routes are not ideal and so require some pretty significant mitigations. I'm happy to answer any questions if that's helpful.
Thank you. Any particular comments from the parties?
I think the generality of having a plan which is properly consulted on and takes into account all these views of locals is absolutely accepted, which is why little Roman 4 is there in the framework for the SEMP. And this kind of very detailed point about identifying which street and so on, obviously, as you know, sir, is often made at inquiries by locals. But it is really the answer to the question rather than the question which needs to be answered at a later stage. And so our firm view is that this is descending to a level of detail which is definitely for the later stage, for the authority, the Highways Authority, in consultation, if they want, with local people, to work out, because apart from anything else, they need to reach that conclusion at the relevant time. And if we write very detailed things in now about particular streets and so on, there have been examples where they've proved not to be workable later because of changes. So really, no pun intended, the detail needs to be parked until that later point.
Mr. Stroud.
I think that's fair. I think ultimately, I think the issues raised are important. They are dealt with within the criteria of the condition. I think what matters, and obviously it's something that I'm happy to pass back on to the council planning team, is that this condition and obviously items Roman 4 and 8 will need very careful consideration at the appropriate time.
So I note this road numeral 4 talk to the detail of the routing, vehicle numbers, type of construction, traffic and associated way marking. And then number 8 comes out with the management of construction traffic and deliveries to reduce congestion, avoid school pickup times and the like. So it's just requesting that level of detail later in a plan to achieve those objectives.
I think that's what it's gearing towards. I think this comes down to a point of whether it would have utility in adding those additional points now or not. I mean, I don't have any issue with it going in, but I understand the points made by the appellant.
Okay, yeah, thank you.
Dad, is that yes, there are things that would need to be in it, but if it was written with the blue wording in, you might not be able to discharge the condition unless you'd put all that detail in, and that I think is the problem that we're both slightly grappling with.
They are the issues that are going to be grappled with, and as I said before, I want to be quite clear that the matters raised by Mr. Morris of vehicle routing and timing, they are taken account of in this condition. They would have to be resolved as part of that, is essentially whether or not it's done now or done slightly later, and the flexibility of being able to do it later. And the council has a programme of consultation on discharging of conditions and the like.
Well, there's certainly formal applications that will be made and be registered and placed on the council's public planning file, so there would be an opportunity, of course, for people to take note of that and respond.
I have in the past shoehorned the requirement that the management plan be developed in consultation with the parish council, for example, or some other particular body, which sometimes can be reassuring to that body. Do you think that would be helpful in this instance?
I think that sounds fair, sir.
Sir, I couldn't quite get your answer. You stated that you had in the past said that parish councils should be consulted. Is that what was agreed just now or not?
So, as I understand from Mr. Stroud, the council wishes in general the planning policies would have a degree of public consultation on the submission of any details to discharge a condition. But what I was talking about was within the preparation of those details. Now, I can't sort of. There are limitations on what you can and can't do with conditions, but in the past I have been able to include a degree of wording that requires not only the submission of an environmental management plan, but that it is developed in consideration with the parish council and part of its submission. So I'm seeking the views of the parties on that, and the particular wording of that can be quite helpful to include you at that point rather than simply on the discharge of the condition, the preparation of the details rather than that, and that being a possibility.
In that case, could the parish council request you do that? And not to beat about the bush, I'm afraid, and you heard it on the first day, there is a very low level of confidence in the Highways Authority and its traffic assessments. I'm sorry to be direct, but that's just the case it is. I believe the planning portfolio holder has used the word, some of your assessments are in la-la land. I say that as a factual statement, so we would very strongly ask that that is put in there so that road safety is protected. The photograph says it all.
Yes, I think, as I say, sir, and if I wasn't clear to the gentleman, we're absolutely happy if you were to shoehorn that in, as you say.
Thank you. And in that case, in fairness to the council, thank you for that.
And also I'd say this is the local planning authority that discharge it, not the local highway authority, if that makes any particular difference. And I note also there's provision under Roman numeral 10 to provide the public contact detail arrangements, complaint management and the like. If there are issues that do arise during the construction period, there will be contact detail.
Absolutely. So can I just make one very, very brief point, which is the type of wording that you have in mind. The only concern that we've got, and it's not a huge concern, but if it imposes a consultation requirement which the developer or the house builder can't control, can't itself discharge, that can sometimes be a problem, obviously, if it depends on how it's written. So as long as it's something that can still be discharged by the developer.
In that regard, I'm quite happy to take a written submission on that if you wanted to produce something of that wording that you.
Yes, I mean, why don't we have a word with Mr. Stroud and come back to you, sir, later on.
That might not be today, but that might be.
That's fine. So I'm sure we can work
Yeah.
something out.
Great, thank you.
Thank you.
On that basis, I don't have any further points or questions in respect to the conditions. Mr. Morris, do you? Or was that the central condition that you were concerned about?
Yes, but if there are going to be further reservations said, I mean, the concern is that the parish council, and indeed the parish councils plural, perhaps even ought to be a party of that. Now, Shenley is an interested party. Aldenham is a formal Rule 6 party, so I take it for formal words. I don't want it to be a stitch-up between the developer and the county. There is a low level of confidence, and
I appreciate that. And what I'm essentially talking to Mr. Warren about there is the specific mechanics, the specific wording of that to ensure that it meets the tests set out in planning practice guidance and the framework. And I'm quite happy to provide you with a copy of that, CC that into you, or indeed do that through Mr. Beglin if you want to have a copy of that and can circulate that. That's quite reasonable, quite possible to do. But I understand what the objective of that is to achieve. Any other comments in that regard? Thank you. Okay. It is 20 to 12 now, which would ordinarily move on to closings. Do we want to break beforehand?
It would be useful, sir, certainly. I mean, apart from anything else to print, but yeah, in your hands, sir, as to how long you'd like.
I appreciate good closings, well considered, well written closings. How long do you want to sort yourselves for that?
I think I'm going first.
Well, I think maybe I. So, well, I mean, we would probably, if you just gave us half an hour, we'd be able to.
I was
get stuff
going longer.
printed
I was kind of thinking it's 1 o'clock. Fine, I'll go have my lunch. You guys can eat a sandwich and write them, and I'll come back after lunch for the closings.
Rather than being in your hands, I was going to bite your hand off on that. So if I can put it that way, 1 o'clock.
I think that gives everyone a reasonable opportunity, because otherwise there are 3 parties. Fine, we'll come back. We'll adjourn there for an early lunch and return at 1 o'clock. Yeah.
Yes, just factoring in the printing, obviously, the sooner we receive, the better. I think if they come to me, then I can forward them straight on to a colleague at the council who can then get them.
Yeah, I mean, in terms of the appellant's printing, and the inspector knows this, what I prefer to do is just wait until I've heard the other 2 closings. I very, very rarely add much at all, but it saves adding orally and you having to write things down. So if we could have, I don't know how long it takes, 10, 15 minutes just to print them after I don't know who's going second, Mr. Beglin or Mr. Cosgrove. We have a short pause there just to print the appellant's closing, that would be appreciated.
Print one copy and email versions as well, just to save time. But yeah, I'm sure that'll work. We'll do our best to make it work.
Okay, fine. We'll adjourn then until 1 o'clock. Thank you very much. Thank you. resume the inquiry now. I will raise costs after the closings, unless you want to go through now.
No,
Closing.
absolutely.
After costs, and I'll cover off any of the documents ID list, suggested condition wording.
I've got that for you.
Okay, we'll do that now then. You've got suggested wording on the conditions or the document list?
Yes, the suggested way, if you're happy to deal with that, so it's brief.
Okay.
I've run it by my learned friends.
Okay.
And it's a suggested insert into that first main paragraph at the top of condition 14, where it says SEM should be submitted to and approved in writing by the local planning authority. That's the wording at the moment. And then insert, we would suggest, with consultation having taken place with the parish council or with Alderman Parish Council, if you want to be absolutely precise about which parish council it is. And then, so that writes in that the approval should be after consultation with the parish council has taken place, but doesn't say that the consultation has to be done by the LPA necessarily. It could be done between the PC and developer if that turns out to be the most appropriate way to do it. Yes, a construction environmental management plan in accordance with best practice guidance, etc., shall be submitted to and approved in writing by the local planning authority, with consultation having taken place with with Alderman Parish Council. Yeah, that makes sense, sir. Thank you.
I think I was going to go first, possibly because Mr. Bigland's still being printed, I think. I'm currently on A1, rather humorously, but mine is ready for circulation. And we've also emailed it to the parties as well, with the hard copies coming, and to your case officer. And so we've tried to keep them short as possible. In the normal way, you'll see we've included references to the inquiry documents, core documents, mostly in the footnotes, and there are a number of quotations we've extracted from various documents which I don't propose to read out as we go through the closings. No, fine. Good, so thanks, sir. So this is an attempted rerun of that which was roundly rejected by Inspector Fagan in January 2024. Whilst there has been some policy movement since then, the relevant MPPF amendments cannot save this, quote, identical scheme from three simple and obvious conclusions. One, this is a greenbelt site. Two, the proposal is inappropriate development. And three, there are no very special circumstances to justify it. As we explore further below, the appellant's second appeal represents a persistent and deliberate refusal to recognise the true landscape character and value of the site and surrounding area. It is an error which infects much of the remainder of the appellant's case and has prevented it from meaningfully engaging with the reasons this application and appeal were refused previously. Here is an identical application with an appellant expecting different results against a background where little has materially changed. In our following section, sir, we summarise the Council's case under the main issues that you identified in your CMC note, identifying further key deficiencies in the appeal as far as they are relevant to those issues. So then addressing your first main issue, and we turn first of all to Radlett in context in light of the evidence you've heard. And a key issue between the appellant and the other parties to this inquiry is in the approach to the role which this site plays in the context of the surrounding landscape. As Brockhurst agreed that if you wanted to easily understand a key difference between the parties, one could, as she put it, pin it back to this fundamental difference of judgment. The appellant is at pains, of course, to portray the site as one which has a close association with the Radlett townscape in an apparent effort to downplay the site's value, and therefore the harm which would arise from the development. But that view, in our submission, misunderstands the landscape character of the site and indeed the surrounding area. The appellant's assessment of the baseline position is another attempt to rerun an argument that's failed before Inspector Fagan. That inspector found that the appellant's evidence, quote, seems to be overly coloured by the site's relative containment by the woodland blocks and its influence by proximity to the housing on its western boundary. The appellant seeks to reject that reasoning without justification and contrary to the observable position on the site. This approach is particularly surprising given the inspector plainly supported the view, now promoted at this inquiry by the Council and the Rule 6 party, that in terms of landscape character, the site is more intimately connected with the countryside than with Radlett. And so we just set out there an excerpt from Inspector Fagan's decision with underlining, which of course is ours. Picking it up at paragraph 8, that result is not simply the reflection of the inspector's site visit, however. It is borne out in multiple documents. Radlett itself is a relatively green area with a character influenced by the surrounding countryside. As made clear in the Radlett neighbourhood plan, it is a, quote, a settlement characterised by its leafy nature with hedgerows, mature trees, green verges, generous front and back gardens. Radlett is surrounded by the metropolitan greenbelt, consisting of arable farmland, grassland, woods and recreational facilities. Indeed, objective 1, of course, of the neighbourhood plan is to, quote, protect and enhance the verdant character of Radlett, whilst the vision section of the document reflects on the identity of Radlett as having, as it puts it, an attractive character as a verdant village. And the housing and design section confirms, quote, one of the key aspects residents love about our village is its verdant nature. Protection of the greenbelt and the above-mentioned character are, as it puts it, by far the most important priorities for the plan. The addendum to the Radlett character assessment also confirms the verdant character of Radlett. Soft features at the edge of the settlement represent a deliberate decision to preserve openness, a sense of transition or arrival, and, as it puts it, key views. And again, so I won't read out the quote, the emphasis, of course, is ours. Picking it up at 11, the authors clearly emphasise the need to preserve and strengthen the low-density edge of Radlett in recognition of its contribution to the verdant character of the settlement. And as explained by Ms Backer in her evidence, the site is a coherent, open pastoral field, including surrounding woodland, forming a critical part of the rural setting of Radlett in this location. It has a specific and important character which draws on its openness and its relationship with the surrounding woodland blocks and indeed the verdant settlement edge, thereby performing a valuable transition between the countryside and settlement of Radlett. These points are all demonstrated, of course, by the visual photographic material before you and will have been evident on your site visit. So then we turn to the issue of purposes in general. The appellant's case rested on the contention, as it put it in opening, that 5 matters made it, quote, unambiguously clear the site did not strongly contribute to purposes A and B. We take each in turn. First of all, the reliance on the Arup assessments. Well, reliance on the Council's previous Greenbelt Stage 1 and Stage 2 Arup assessments must now be rejected in light of Mr. Allen's answers in cross-examination. He accepted that the Arup assessments did not utilise or address the same guidance that national policy now requires decision-makers to consider. The shortcomings of these documents were in any event recognised, of course, by Inspector Fagan, and we've set out a quote from his decision where he dealt with them. The second point, the inspector's site assessment. Both Ms Backer and Mr Stroud considered that if informed by the updated guidance, Inspector Fagan would likely consider now that the site did make a strong contribution to the relevant purposes. The third point relied on the CSA review. The appellant's desire to place any reliance on the CSA Environmental Greenbelt Review of July 2024 is remarkable. It is a document with which the appellant's own planner, and indeed everyone else, disagrees. The document considers that the site makes a weak contribution to Purpose 1, whilst Mr Allen considers it to be moderate. Similarly, the document states that the site makes, quote, no contribution to Purpose 2. Mr Allen considers that contribution to be moderate. It's a document drafted on the basis of an entirely different definition of grey belt, which was not actually taken forward by the government in the December 2024 MPPF, and which appeared to utilise criteria of no relevance or similarity to the present government policy. Then in relation to the officer assessment, The relevant exercise is quintessentially one of judgment, and there are 4 professional experts at this inquiry who have provided detailed justification for their view that the site does perform strongly against purposes A and B, and who urge you, sir, to agree. The officers did not have the benefit of being able to consider such a body of experienced landscape and planning expert assessments that are now before you. The advice from Mr. Cannon offers little practical support for the appellant's position. First, unlike the current position, there was before him no expert evidence to support an assertion of a strong contribution to purposes A and B. But second, the conclusions within the advice are partially based on the Arup studies, which Mr. Allen agreed offered little assistance. Finally, the advice is rightly caveated on the basis that the key question was, as he put it, will usually turn on a series of planning judgments made about certain aspects of the definition of grey belt. Was accepted again by Mr. Allen, none of the advices purportedly relied on had considered the expert evidence available at this inquiry, which of course, through Ms. Brockhurst, the appellant has accepted, provided a reasonable basis for findings of strong contributions. So we set out the following agreed points as to how you approach the purposes and the guidance below. First, the amendments to the MPPG in 2025 address specifically the identification of grey belt land. B, the assessment tables provided within the guidance are provided as, quote, considerations for informing judgments, and cite various, as they put it, illustrative features. C, it necessarily follows in our submission that those features are not exhaustive or intended to be rigidly applied. Instead, they offer prompts to aid in the assessment of the types of characteristics that are likely to be present in determining whether a purpose is performing strongly, moderately, or indeed weakly against its definition. D, as Mr. Allen accepted in cross-examination, such guidance was not meant to be a tick box exercise. E, moreover, despite suggestions to the contrary by the appellant, the guidance gives no indication that any particular weight or importance is to be given to any particular feature or consideration, as Mr. Allen eventually agreed. A judgment is required in each case. For example, it was accepted in the end by Ms. Brockhurst and Mr. Allen that it was possible for a physical feature to be present which restricted further development, and yet the site in question be found strongly to contribute to purpose A. See, for of that example in action, the Marlowe decision recently by the Secretary of State. So then we turn to the specifics of purpose A. Ms. Brockhurst's evidence at this point is fairly fundamental to the appellant's case, as she informed the inquiry that it was her judgment on purpose A that had been taken up by Mr. Allen in the planning evidence. Her evidence was, with great respect, confused and highlighted material omissions in her written proof. When asked what level of contribution she considered the site made to purpose A, her answer was short: I'm with Arup. As was clear from the evidence, not only had the Arup studies failed to apply any criteria relevant to up-to-date policy, but in relation to purpose A, the assessment had not, in fact, considered the site at all, given Arup had also erroneously concluded Radlett was a village. Eventually, Ms. Brockhurst then told the inquiry that she considered the site made a weak contribution to purpose A, later seemingly suggesting her assessment was in the weak to moderate category. That was not an analysis which had been set out anywhere in her written evidence. Mr. Allen had recorded that the relevant contribution was moderate. In short, Ms. Brockhurst came to no conclusion in writing on this key topic, then came up with an assessment and evidence which was contrary to her fellow and indeed most other experts. Against that backdrop, it is very difficult to give much credence to the appellant's case on this point. It was eventually agreed that the development of the site would comprise sprawl, and it is obvious, in fact, that it is adjacent to a built-up area. That is a good starting point for a purpose aimed at checking the unrestricted sprawl of large built-up areas. Much of the remaining discussion before the inquiry was about whether there was a degree of containment external to the site, or whether the pattern of development of the site would be incongruous or not. Ms. Brockhurst accepted that it was conceptually possible that a site could strongly contribute to purpose A, having physical factors in reasonable proximity that restricted or indeed contained development. That is quite right. The guidance, as I've said, is non-exhaustive, and the Secretary of State reached such a conclusion in Marlowe. Here, As explained by Mr. Stroud, the site's contribution to purpose A is intimately related to its spatial and visual role at the settlement edge of Radlett, as we've already set out. The site at present represents a check against sprawl because it forms part of the existing functional boundary of Radlett. Contrary to the view expressed by Mr. Allen in his proof, it provides a soft edge to the settlement which arises as a result of the verdant character of Radlett, the sloping topography of the site, and the presence of openness and further green framing set against the lower density development at the existing boundary of the town. Here, at the settlement edge, these features mean that the physical and visual influence of built form is limited, decreasing the perception of built form as the edge of settlement meets the countryside. And as explained by Mr. Stroud and Ms. Backer, development of the site would result in an incongruous pattern of development. In the end, the appellant's evidence was in a state of disarray. Ms. Brockhurst, when pushed, had identified that the site made only a weak contribution to purpose A and B. This differed from Mr. Allen's conclusion that the site made a moderate contribution to the same. Fairly and correctly, Ms. Brockhurst had accepted that Ms. Backer's conclusions on strong contributions to purposes A and B were based on reasonably made judgments. By contrast, Mr. Allen asserted there was no evidence that could reasonably support a finding of a strong contribution. In turn, his conclusions of moderate contributions disagreed with the CSA review on which his clients had relied in their statement of case to this inquiry. Mr. Allen's assertion that there was no evidence to support a reasonable conclusion as to strong contributions represented a head-in-the-sand approach. It failed to engage not only with the demonstrably thorough evidence produced by 4 independent experts, but also with the evidence of the principal expert put forward by the appellant to address site's contribution to purposes, when challenged that the threat and cost application against the council, apparently on the basis of there being no evidence to justify a refusal, was both unsustainable and unreasonable. In light of the evidence relied upon by the appellant through Ms. Brockhurst, he provided no reasoning whatsoever to justify a continued pursuit of costs. These points apply with equal force to the approach taken to purpose B, to which I now turn. The appellant appears to put its case as if this purpose could only be strongly contributed to by a site which prevented neighbouring towns from actually merging together. Ms. Backer was asked to agree, for example, that approving the instant development would not actually result in a dictionary definition of merging. Fairly, the answer is no. But the line of questioning is premised on a misreading of the function of purpose B and the accompanying guidance. Plainly, a strong contribution can be made by a site which forms, quote, part of a gap between towns, but does not comprise the entirety of the gap itself. That is just what the guidance says. Mr. Allen agreed this. Quote, the test is not whether the site prevents neighbouring towns merging together, but whether the site makes a contribution to that purpose. Inspector Fagan clearly identified concern over the gap between Radlett and Boreham Wood, noting, quote, the existing 1.7 kilometre and 1 kilometre gaps are relatively small gaps between settlements which are fairly characteristic of the metropolitan green belt, and it is important to spatially preserve open land between such settlements if the policy is to continue to be an effective planning tool in the metropolitan green belt. Rightly, he found that the less of a gap there is between settlements separated by the green belt, the most important those gaps are in terms of purpose B. Of course, by dint of neighbouring development, the relevant gap has decreased since his assessment. Ms. Brockhurst agreed that the approach adopted by Inspector McCormack in the recent Seaview Drive appeal was appropriate. She agreed that consideration of perceptual factors were also important when addressing purpose B. The inspector there concluded, and so we set out that quote which you looked at the inquiry, and just drawing your attention, that inspector felt that if you didn't do that kind of exercise, it would only be a partial assessment. You'll see there. 27. On this point, Ms. Brockhurst agreed that Ms. Backer had formed a judgment which she was reasonably entitled to come to, and indeed put before you. Indeed, she recognised it was a conclusion that 4 expert witnesses had also reached. With the appropriate approach to the guidance understood, Ms. Backer's analysis as to the strong conclusion on purpose B is plainly correct. The site is presently part of a gap between Radlett and Boreham Wood. The gap between settlements is relatively small, as Inspector Fagan found above. As Ms Brockhurst accepted, the site itself is large. The site's openness, which we explore further below, presently contributes to preserving the gap. And the site's function as a green buffer, forming a soft transition from urban edge into surrounding countryside, coupled with the topography which falls away from a developed edge, means that the site strongly contributes to a sense of separation of Radlett and in providing the settlement a particular identity. In visual terms, the loss of this feature would result in the perception of a closer urban edge, and the edge would be experienced far more abruptly. This is precisely the kind of perceptual contribution over and above the mathematical calculation of distance, which should rightly be taken into account when considering the extent of contribution of any given parcel of land. In this case, coupled with the more prosaic features enumerated earlier in the list, this factor makes it abundantly clear that the site makes a strong contribution to Purpose B. Mr Stroud adopted a similar analysis, additionally making the point that the appeal site is orientated such that the bow wave of development would be sprawling directly towards Boreham Wood. This highlights the importance of the site in strongly contributing to the purpose, again, of preventing the towns from merging. So then we turn to openness. Ms Brockhurst fairly agreed that there was nothing between her view and that of the council concerning impact on openness, and that she essentially accepted the conclusion of Inspector Fagan on that issue. The relevant passages of that decision concerning openness on which the council relies are as follows, and so we've set them out with references. I don't read them all out at this stage. Then I pick it up at paragraph 30. Given the extent of the agreement as to the accuracy of those conclusions, little more need be included here. However, for completeness, it is noted that a similar view was reached by officers in the determination of the latest application at the site, and so we've then just quoted from core document 2.3 with underlining being ours again. So then I turn to main issue 2, the effect of the proposal on the character and appearance of the area. Much of the relevant material concerning value is set out above in the submissions we made in the site context section, and so we don't repeat it. But the fundamental difference between the parties concerning landscape impact arises from the divergent views on context between Ms Brockhurst, Ms Brown, Ms Backer, and indeed Inspector Fagan. Ms Brockhurst forms her lower judgment on value whilst noting, quote, "I accept that others would disagree with me." She had provided an assessment of value lower, in fact, than any other assessment before the inquiry. On sensitivity, Ms Brockhurst was again in the minority. In arguing for a finding of low sensitivity, she differed from even the LVIA performed by her client's earlier expert CSA. To the extent any support is sought from the outline landscape appraisal document, the limitations of that document were exposed and its utility rejected, of course, by Inspector Fagan, and we've given you again the relevant quote with emphasis. Ms Brockhurst accepted that Ms Backer's view on sensitivity was in accordance with that of Inspector Fagan, and that the inspector had formed his view after hearing, of course, detailed landscape evidence. Ms Backer's views are effectively summarised at table 1 of her proof, broadly identifying a higher level of sensitivity than that within the LVIA. Set against the analysis already undertaken by Inspector Fagan, it is a conclusion which is eminently justified and we say clearly accurate. Yet again, much of the difference between the parties on sensitivity appears to arise from the appellant's contention that the site is more closely related to the urban edge, a view contrary to the evidence of Ms Backer, Ms Brown and Inspector Fagan's analysis. As to magnitude of change, the relative levels on which the Council relies are summarised in Table 2 of Ms Backer's evidence. It's noted that while some effects may reduce after 10 years, Ms Brockhurst accepted there would still be some substantial effects at that time. In any event, there doesn't seem to be a great deal of difference between the parties in respect of the eventual degree of character and visual harm arising as an effect of the scheme. Ms Brockhurst accepts that the scheme would give rise to, quote, quite serious substantial effects identified over a period of time, and also informed the inspector that she essentially agreed with the findings of Inspector Fagan on this point. And for clarity, sir, we therefore set out the relevant analysis of Inspector Fagan in those passages with references to where you find them in his decision. Any suggestion that those conclusions on effects was narrowly confined to the site itself is of course undermined by the clear reference to impact on the area within the final passage quoted above, as indeed by the obvious impact that developing 8 hectares of land would have on the surrounding area. Indeed, as Miss Brockhurst accepted, a finding of substantial adverse effect had been given by every single person who considered the proposed development or its predecessor. Ms. Brockhurst's conclusion that substantial adverse effects were, quote, not significant effects is difficult to understand, especially given her evidence was, as above, that the relevant effects were, quote, quite serious. It's not a position adopted within the LVIA, or by any officer, or by Inspector Fagan, or indeed anyone else who's considered this application. The basis of her justification for her controversial view was apparently found, she told us, in the definition of significant within the glossary of Glivia, which is, quote, a measure of the importance or gravity of the environmental effect defined by significance criteria specific to the environmental topic. Inherently, this is a definition concerning EIA development, so is plainly of little utility, but the main point appeared to be that because the substantial effect was relatively local, it was, in her view, not significant. The obvious effect of this is to sidestep much of the nuanced process for considering value, susceptibility, and sensitivity. If such an approach is justified, it would facilitate a denial of significance in many similar contexts concerning residential development. In fact, a key factor which Miss Brockhurst had utilised to inform her judgment on significance was found in her proof, where she opined that the development within the appeal site was, quote, the inevitable and unavoidable consequence of delivering growth in line with the aspirations of national and local governments. Clearly, she had imported a distinct policy judgment irrelevant to landscape or visual effects into her judgment of the significance of landscape and visual effects. This is not an input that should have any place in an assessment by a landscape expert. Miss Brockhurst appeared to recognise this herself, eventually reflecting, perhaps I shouldn't have written that. Weight to housing delivery is a matter which Mr. Allen deals with in his planning balance, and to which he gives very substantial weight. But that is the same consideration that Miss Brockhurst has used to reduce the level of effects that she reported to Mr. Allen. This results in a position in which this benefit is double counted, which is obviously unacceptable. The proper approach is to afford substantial weight to these landscape and visual effects, such approach having essentially been adopted by Mr. Stroud, Miss Backer and Inspector Fagan. And so we explore the relevant weightings in the next section. So main issue 3, the very special circumstances analysis. Very special circumstances for the purposes of MPPF 153, quote, will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal was clearly outweighed by other considerations. It follows that harms and benefits must be identified and then weighed against one another. The scheme would give rise to the following harms, which should be awarded the following weightings. First, landscape and character and visual harm. As set out above, this is a matter which should be afforded substantial weight. Mr. Allen was alone amongst the planners at the inquiry in seeking to afford this matter any lesser weight. His reason for doing so appeared to stem from the erroneous input from Miss Brockhurst, as we've set out above. Secondly, definitional harm to the greenbelt by virtue of inappropriateness, substantial weight by virtue of 153 MPPF, and harm to greenbelt openness, again, substantial weight by operation of 153 of the MPPF. Mr. Allen agreed that the decision of Inspector Fagan was itself a material consideration weighing against the grant of permission, given the importance of the principle of consistency in planning decision-making. As to the benefits of the scheme, insofar as the Council's position diverges from the appellant's, Mr. Stroud's clear evidence on this point was in accordance with the conclusions reached by Inspector Fagan. The provision of market housing should attract substantial weight, as explained by Mr. Stroud. Again, that was the conclusion reached by the previous inspector. A greater degree of affordable housing has been provided than was proposed in the scheme before him. Accordingly, there is less market housing proposed, than before that inspector in that context. Adopting the same level of weight Inspector Fagan adopted is entirely appropriate, allowing, of course, for the reduction in local housing land supply and acknowledging that Inspector Fagan came to his reasoned conclusion by reference to other relevant planning appeals and what we submit as a clear understanding of the importance of housing provision. It's right that the provision of safeguarded land for the expansion of Newbury's primary school be afforded limited weight. That is a matter which arises as a consequence of additional demand caused by the appeal development itself and is not a freestanding benefit. Affording this matter limited weight, and the reason for doing so, is consistent with the decision of Inspector Fagan, and nothing has changed on this point since the previous appeal decision. On BNG, this matter should be afforded limited weight consistently with the determination of Inspector Fagan, again highlighting that little of consequence has changed on this point since his decision. A challenge to his conclusion was part of the appellant's claim, so it will be noted, before the High Court, which was dismissed. Plainly, the approach adopted by Inspector Fagan was eminently reasonable, and there are no reasons now to depart from it. In respect of economic and social benefits, these too attract limited weight. The relevant benefits are typical of those one would expect to see in a residential development of this type. Inspector Fagan took into account national support for economic growth before considering that lesser weight should be afforded to this matter where the location of the development was contrary to Greenbelt policy and where a plan-led system is the appropriate mechanism for determining the distribution of growth and associated benefits. It's right that connectivity benefits should be afforded very limited weight. The relevant works are necessary as a result of the scheme and again are similar to mitigation rather than independent benefits. Further to the above, Inspector Fagan found he would not have found very special circumstances to be present, even were he to have afforded much greater, in his terms, significant weight to both the economic benefits of the scheme and benefits arising from the new health facility. Quote, even if I'd given significant weight to the new health facility and the economic benefits, the totality of these other considerations would still not clearly outweigh the overall harm the development would cause. Mr. Allen fairly agreed against this backdrop that Inspector Fagan's judgment allowed for, quote, a degree of leeway. Clearly, adopting the inspector's reasoning in keeping with the principle of consistency encourages a decision-maker to decline to find that there are very special circumstances, even if one were to depart from Inspector Fagan's finding on benefits. So weighing the above harms and benefits, Mr. Stroud's clear and well-reasoned conclusion was that the benefits of the scheme do not outweigh, still less clearly outweigh, the harms of the scheme. In fact, his evidence was that even if he were to agree with the weightings provided by Mr. Allen, the harms would not be outweighed by the benefits identified. In such circumstances, the clear direction of national policy is that permission should be refused for development in the Greenbelt. So for those reasons, the proposal we submit is contrary to both national and local plan policy, and accordingly planning permission should be refused and the appeal, not the application, the appeal dismissed. Thank you very much.
So, sir, thank you. These are the closing submissions on behalf of Aldenham Parish Council, the Radlett Society and Greenbelt Association and Save Hertsmere. And I start with the introduction. By this second appeal, the appellant again seeks permission for substantial residential development of up to 195 homes, expansion space for Newbury's primary school, new medical centre with associated access, landscaping and parking on land south of Shenley Hill in Radlett. And the authority refused the application for the reasons that we have seen. The Rule 6 parties support the case contained in that reason for refusal and indeed support and echo the closing submissions that have just been made on behalf of the local planning authority. So as you know, we also advance related points on, amongst other things, whether the development will be in a sustainable location, if, where applicable, the golden rules are satisfied, and in relation to the weighing of the case in very special circumstances. And I turn next to the nature of this second appeal. The take-two nature of this appeal is amply demonstrated by the lack of any substantial refinement of the proposals to address the various shortcomings identified by Inspector Fagan following an extended inquiry into the merits or otherwise of the scheme, the more explicit requirements in relation to green spaces contained in the MPPF and PPG guidance, the specific, explicit and detailed advice given by Place Services in assessing the application, and the local nature recovery scheme in draft or as adopted in line with the requirements of paragraph 159 of the MPPF and the accompanying planning practice guidance. And it will be noted that the overdevelopment point is supported by the advice Place Services gave, as well as the expert evidence of all the witnesses called by the local planning authority and the Rule 6 party. The outlined nature of the proposal cannot save it from this point, because the quantum of development proposed, and that the Council could not resist should this appeal succeed, being 195 units, precludes compliance with these requirements. And the tenor of the Place Services advice is not of tinkering around the edges, but an overdeveloped scheme in need of an overhaul. In matters save for Greybelt, the decision of Inspector Fagan continues to provide a reliable guide from which departure should only be made after careful consideration, applying the well-known and accepted principle of consistency. And the claim changes now sought to be advanced by the appellant in that respect are overblown. The housing situation was already poor when the matter was before Inspector Fagan. The other issues raised by the appellant do not command the same kind of weight as consideration of housing, as was agreed in cross-examination by Mr. Allen. Inspector Fagan plainly approached the appeal on the basis that there was no prospect of a then deteriorating position reversing itself in the near future. We are still in that near future. His decision was made very recently in 2024 and in relation to the same site. And that is important when assessing the different weightings that other inspectors may have given the issue of housing provision in different circumstances relating to different sites and potentially using different scales of evaluation. The appellant has fallen into precisely the trap on such weightings that Mr. Justice Holgate, as he then was, said should be avoided in Fairfax. Moreover, what is entirely clear from Inspector Fagan's decision is that this was not a close call in his judgment. The case in very special circumstances was so weak in comparison to the harms that he could confidently say that even if a number of benefits had been weighed more positively in the scales, it would not have changed the outcome. This is unsurprising in light of the conclusions he reached on the issues of the level of harm to the green belt, to its purposes, and the substantial adverse landscape effects. The practical consequence of this is illustrated in the Fairfax decision, and I've given the quote to the judgment. The only further benefit that can arise in substance is the mandated significant weight to be given to full compliance with the golden rules, but the appellant has failed to demonstrate that compliance on the evidence provided by the Rule 6 party. In any event, that one factor would not overcome the overall approach of Inspector Fagan as summarised above. And for those reasons, there is a fairly straightforward path to determining this appeal. First, the site does not comprise grey belt land. And second, no sufficient reason has been demonstrated to depart from the clear conclusion of Inspector Fagan in relation to substantially the same scheme on the same land. And Mr. Stroud characterised that decision as a blueprint for considering the remaining issues. But below, the Rule 6 party sets out in some further detail the support for those two conclusions. Turn to consider the site, which as we know comprises 11.45 hectares of greenbelt land on the southeastern edge of Radlett. It is a large site. The majority of the site is an agricultural field. None of the exceptions to it being greenbelt apply because it is not greybelt land. It is not in a sustainable location and, as we say, does not in any event satisfy the golden rules. The land is not allocated for development. The history in this respect has some interesting features. In the 2021 Regulation 18 version of the local plan, it was proposed to be allocated. There were substantial objections to that version of the plan as described by Mrs. Scott. That led to the 2024 Regulation 18 local plan, which did not allocate the site. It is noteworthy that in relation to this edge of Radlett, from which Theobald Street runs down to Boreham Wood as the main route between the two settlements, and perhaps more generally in the proposed allocations, they were largely in the nature of rounding off the settlement. That is demonstrated taking, for example, site HEL 214 in relation to Radlett, which rather than accentuating the triangle of land and creating an incongruous pattern of development to Radlett, as the site would do, rather sought to round off that part of the settlement up to the railway line. The plan of Radlett from the 2024 version, making 4 allocations adjacent to the built-up area, shows the point well. The extent of the eastward extension caused by the site is some 250 metres, as measured by Miss Brown using a scale CAD drawing. The incongruity is further shown by the access to this substantial development being taken from Shenley Hill. And it is odd for the appellant, if they still do, to praeonate certain parts of the evidence base supporting those rejected local plans, yet apparently ignoring that the most recent result of that process was the deliberate exclusion of their site from a list of allocations that, as it happened, appeared to have been more geared to, or resulted in, avoiding incongruous Greenbelt allocations. At all events, the result in the 2024 Regulation 18 plan supports the evidence of the local planning authority and the Rule 6 party in relation to the incongruity of the site. And there will be further evidence-based work, as we know, before further site allocations are proposed within the local plan process, but they will now have to consider the relevant grey belt tests and guidance, and it is far too early for the appellant to predict with any confidence that this site would be allocated. Apart from anything else, Hertsmere would be far from alone in the list of highly constrained authorities if it submitted a plan that did not meet its housing needs in full, or decided to exclude from allocation sites which made a strong contribution to key purposes of the Green Belt. So I turn to the case that is advanced in very special circumstances. Very special circumstances are required to justify this development, and they will not exist, as we know, unless the potential harm to the Green Belt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. As recently as the 26th of January 2024, Inspector Fagan concluded that the appellant's proposals did not meet that high threshold. As set out above, there is no reason to reach a different conclusion on this occasion. Amongst other things, it is trite that, insofar as claim benefits are simply the proposed development consuming its own smoke, they are not to be weighed positively in the scales. And as we've identified in the evidence, a number of substantial harms arise from the proposed development. They include definitional harm, harm to spatial openness, harm to visual openness, harm to 3 of the 5 purposes of including land in the Greenbelt, namely to check the unrestricted sprawl of large built-up areas, to prevent neighbouring towns from merging, and to assist in safeguarding the countryside from encroachment. In addition, the proposed development causes substantial landscape harm. Harm by visual impact also arises. The proposed development will undermine the site's contribution to the Watling Chase Community Forest, and residents of the 21 dwellings that back onto the land in Newbury's Avenue, Williams Way and Shenley Road will have severely affected amenity. In relation to those harms, the preparation of the application had serious shortcomings, which on each occasion had the result that the harms caused by the proposed development risk being downplayed unless and until those issues were corrected. 2 obvious examples are the unexplained absence of winter views in the photography and the absence of AVRs despite the advice of police services. As Miss Brown confirmed, the A1 AVRs, which the inquiry has had access to if individuals wanted to consider them, and produced by her, are verified to level 3 and do comply with the applicable guidance. The overdevelopment of the site will preclude the required LNRS improvements. This is an issue that the appellant accepts but has not been considered in this resubmission. It is simply not addressed anywhere in the papers in support of the appeal. That is a clear failure, bearing in mind that the LNRS strategy has been in draft and through the consultation process before being recently adopted. The PPG requires that on-site provision should be made unless it is demonstrated that cannot be done. No such attempt has been made. Moreover, as Mr. Allen accepted, Action 3 of the focus area, affecting roughly half of the site, requires the creation of more good quality neutral grassland, but it is common ground that a substantial negative impact in landscape terms is precisely the loss of that neutral grassland from the site. So I turn now to consider the issue of greenbelt and greybelt land. As we know, the whole of the site is designated greenbelt. The definitional harm to openness and harm to the purposes of the greenbelt are clearly established by the evidence. And in order to meet the definition of greybelt in the MPPF, the land must not make a strong contribution to as relevant purposes A or B of the land being in the green belt. However, this rural site does make a strong contribution to both of those purposes, and 4 witnesses have now spoken to that conclusion. It is now common ground that the relevant planning practice guidance is illustrative, not exhaustive in terms of considerations that may fall to be applied, and that the illustrative questions posed in the guidance act as prompts to an assessment. A planning judgment is ultimately required. The Marlowe decision of the Secretary of State is a clear example of such a judgment at work. It also demonstrates the Secretary of State considers that contained sites can make a strong contribution to preventing unrestricted sprawl. The reference in that case to rounding off has been noted above, but the proposed development is the converse of that position. In terms of urban sprawl, the site is of significant size and will demonstrably cause the sprawl of Radlett. It is adjacent to a large built-up area. It moves down the road, connecting the 2 towns of Radlett and Boreham Wood, just as Organ Hall Farm moves up the same road from the opposite end. It is presently free from development and does not have detracting features. In addition, the site reads as clearly rural, associated with the countryside. That is its intrinsic character, and it is this intrinsic character that has been serially downplayed by the appellant. The appellant's case is one that Inspector Fagan roundly rejected, and rightly so. The minor roads and commercial plantation will not provide substantial permanent physical features containing further development. The plantation at Newbury's Woodland is reaching an age where the trees are likely to be felled. There are already large areas of deforestation that appear to have occurred recently. The felling licences recently produced do not support the appellant's case. Even in their present form, they allow substantial thinning of large sections of the woodland, including importantly in areas immediately surrounding the site on parcels 4, 3A, 3C, 3F, 3H and 3I from the operations map. Notwithstanding the presence of the licences from 12th of July 2023, no ZTV analysis was conducted to see what changes that might or had led to on the land. It is material that the land was, until very recently, being marketed for sale and could just as easily be put back on the market in the near future. Mrs. Scott's evident scepticism of the recent removal from Savills was an unsurprising reaction in circumstances where large tranches of woodland had been put up for sale in a sequence of lots precisely on the basis that they were presently ripe for residential development because of the precarious housing land supply position. When earlier in the proceedings, Miss Brown was asked about whether it was a point she would have applied directly to woodland that was not protected, she said, "Not necessarily. I just think in this case there is good evidence that this woodland is under threat." She was clear that what was occurring was more than thinning. Miss Brockhurst was clear that in the event of clear felling by a new owner, it would not remain as a permanent feature or be a physical barrier. However, due to the lack of any ZTV analysis, it is not easy to gauge how extensive views of the development might become in those circumstances. Now, development of the land will cause an incongruous spread of Radlett in light of the quality of the land, the nature of the surrounding transitional development, and the creation of a large triangle of open land to the south of Theobald Street. There has been no persuasive answer from the appellant to the resulting edge in Radlett in that respect, if the appeal were allowed. In relation to purpose B, the situation has also changed significantly on the ground with the grant of permission on the 2nd of October 2024 for the Organ Hall Farm, Theobald Street, Boreham Wood, and land development of 110 dwellings and associated development. From the edge of that development to the edge of the land is in the order of 900 metres along a 40-mile-per-hour road. Organ Hall Farm is a substantial development with a new access, and even looking at the reserved matters or illustrative master plan, will have managed green space with residential activity considerably outside the built development. It will read as a further substantial reduction of the main route between the two settlements. On any view, the site forms a substantial part of the remaining gap between Radlett and Boreham Wood, as well as the gap between Radlett and Shenley. As noted above, it is presently free from development, does not have detracting features. It reads as clearly rural, and the proposed development is directly facing in towards Boreham Wood. It would be recognised as moving towards merging the two settlements. All the authority and Rule 6 party witnesses are clear that the gap as exists is a relatively small one between the two towns. Inspector Fagan reached that same conclusion. So to set up straw men, such as you're saying you wouldn't be able to tell which settlement was which, or requiring actual merger between the two towns, does not assist in answering this question. By that stage, plainly, as Inspector Fagan recognised, national policy would have been defeated. For similar reasons, and bearing in mind the facts above, in this case, exhortations to look for this purpose, at whether the proposal would be within a small part of the Greenbelt overall, does not provide significant assistance in determining this issue. Rather, as Mrs. Scott emphasised, it is very important to the settlement pattern that these towns do not coalesce. And in that respect, Inspector Fagan made certain observations at paras 20 and 21 of his decision, which we've set out there with emphasis, and which I don't read presently. I move on to paragraph 37, noting that the other side of the coin of the observations that Inspector Fagan did make is that a strong contribution arises in this case. If development on a parcel of land would render ineffective the Greenbelt policy, that is because a strong contribution is being made to its main purposes. The point about retaining the effectiveness of the Greenbelt in approaching its purposes was restated in different words in the Lancaster appeal. I've given the reference in the footnote. The inspector recognised the overall planning judgment required, and that undue focus on the percentage reduction of the strategic gap would lead to constant promotion of small-scale changes through development proposals. In that case, the self-contained site was easily distinguishable visually and physically from the wider countryside. But that is not the case here, and that form of distinction serves to further underline another feature that strengthens the contribution the site in this case makes to Purpose B. In his decision, Inspector Fagan acknowledged the value of the site to those two purposes as well as to Purpose C, and it was not necessary to his conclusion to consider whether either Purpose A or B made a strong contribution. The concept of Greybelt land did not fall to be applied at that stage for obvious reasons, and he did not have the benefit of professional evidence on the application of the Greybelt guidance. It is entirely likely that, on that basis, he would have recognised the site making a strong contribution to both purposes. At that stage, the distance under consideration was of the order of 1.7 to 1.4 kilometres, but now at less than 1 kilometre, that has already been substantially reduced by measurements in the order of 40% to 70%. The importance of the inspector's observations remain today, and the contribution made to Purpose B is all the greater, employing the logic he used in paragraphs 20 and 21, which we've set out above. Now, against the backdrop of clear professional expert advice about the strength of the contribution to these purposes, which was consonant with the strength of the conclusions arrived at by Inspector Fagan, the appellant's reliance on historic documents generated for other purposes which simply do not address the applicable tests or represent the views of lawyers rather than planning professionals is telling. I turn next to the Golden Rules. The Golden Rules are designed to achieve high standards in relation to those exceptional cases where non-allocated greenbelt sites are to be developed. For example, they require 50% affordable housing. They also require accessible, good quality green spaces. The site wholly fails to provide spaces of such quality, which should, amongst other things, contribute positively to the landscape setting of the development and support nature recovery. And it is quite clear that paragraph 159 of the framework contains requirements of the golden rules. They are not an add-on or a nice to have. As Mrs. Scott said, paragraph 159 provides explanation and clarification of the earlier paragraphs 156 and 157. And the appellant's railing against this interpretation of paragraph 159, to my note, Mrs. Scott may have been asked about it in the order of 4 times, and the substantially unmodified nature of this scheme, simply serve to emphasise the absence of any effort to comply with those provisions. It is trite to say that the inspector has to assess this unrevised scheme against the now applicable guidance and strategies, and the scheme fails. That means it doesn't fall within the exception. On the evidence, it does not. There are not improvements to public accessible green space that can be accessed by occupiers and the general public that, as they must, contribute positively to the landscape setting of the development, nor improvements that provide on-site support for nature recovery. An overarching feature facing the site, effectively unrefined from the last occasion, despite the clear advice of place services, is that of the quantum of development. The illustrative proposals show that 8 hectares of the site would be developed for the new homes, medical centre and access roads. Seeking such a high level of development has caused a raft of issues in relation to the proposed development. And it is not landscape-led. It has a density and layout that fails to reflect the settlement pattern and character of Radlett, notably and in particular the nearby area around Faggots Close and the area of Williams Way, with larger plots and more incidental green space within the public realm. The verdant nature of Radlett is a central theme of adopted development plan policy in the Radlett Neighbourhood Plan. It's taken up within the objectives in Policy HD3 and in Policy HD7 relating to the various groups of bungalows in close proximity to the site. In Radlett, the average number of dwellings per hectare is 11. The nature of the residential development in the vicinity of the land is clear from a cursory view of the surrounding roads. But in stark contrast to this, the proposed development seeks to accommodate 36 dwellings per hectare, a level of overdevelopment that is wholly inappropriate. Of course, density is only one factor and does not fall to be applied crudely, but the striking nature of the contrast here is unavoidable. Now, the proposed development offers poor green space provision. There is a lack of functional green infrastructure through the site, and the green amenity spaces, play area, and sole usable amenity space are poorly located and appear as leftover areas rather than being informed by the landscape strategy. Ms Brown was clear that the proposed development did not comply with the golden rules in that respect. In those circumstances, the lip service given in the design and access statement to a landscape-led scheme, but not meaningfully developed elsewhere in the evidence, needs to be seen for what it is. The failure to consider revising, or to revise, the scheme in light of the points raised above regarding place services and local nature recovery strategies simply serve to underscore that point about the unfortunate, standardised nature of the proposal being put forward. A further failure relates to the poor connectivity of routes for active travel, contrary to the vision and proposals of the Radlett Neighbourhood Plan. The site overall will read overwhelmingly suburban with an enclosed character. There will be adverse changes to various elements of the landscape, including substantial adverse effect to the overall site. The evidence of Ms Brown demonstrates adverse impacts to each of the 6 landscape receptors identified in the LVIA, and consistent with that, Inspector Fagan found substantial adverse landscape effects on the site as a result of the permanent residential development of 8 hectares of it. On analysis, the sustainability of the site is also in question. It is acknowledged that it is located on the edge of Radlett, but paying particular reference to paragraphs 110 and 115 of the framework, issues remain. This is due to its distance from the centre of Radlett, the lack of local facilities, and the unsatisfactory nature of pedestrian and cycle links to access the shops, services and railway station in the town centre. Accordingly, for those reasons, the proposed development is not on Greybelt land and in any event does not comply with the Golden Rules. It causes substantial landscape harm and harm to visual amenity. And so briefly, in terms of other harms, noting what has already been described above, we go back to the harm to the site's contribution to the Watling Chase Community Forest as described in our evidence, and the issue in relation to visual harm. We've discussed in my closing submissions the preclusion of enhancement of the neutral grassland habitat to meet local nature recovery strategy objectives. And this more recent but important requirement, as we note, simply not addressed by any proposed revisions to the scheme. It is another example of opportunities lost. So when you draw all of those factors together and we return to the very special circumstances test, we note that there's very little by way of additional benefit beyond that relied upon for the previous scheme for reasons that we have set out. It did not come close to meeting that test in 2024, and it does not come close now. And for the reasons set out in detail in the evidence both of the authority and the Rule 6 party, the substance of the position remains the same now as it did then in January 2024. The appellant fails the applicable tests. So it follows from that allowing the appeal would be in conflict with key provisions of the MPPF. And then lastly and briefly, looking at the same analysis but through the lens of the nature and extent of conflict with the development plan, the local planning authority and Rule 6 party evidence shows that the overall development approach is contrary to various policies in the core strategy and the Radlett neighbourhood plan for the reasons set out in our evidence, and they include policies CS 12, 13 and 19 of the core strategy, policies 3, 11, 12, 26, 27 and 30 of the site allocations and development management plan, and in relation to the neighbourhood plan, policies HT3, HT5, 7, RV2 and GA1. So in all those circumstances, we say that the appeal should be dismissed. Thank you.
Thank you very much. It's gone to Mr. Stroud and others. Thumbs up from Mr. Stroud. That's a good sign. the PPG list of factors. And I turn to that, the additional factor that the council relies on. So actually, in the end, the only, as it were, new or additional factor beyond the factors the government has identified, the council points to, is the rural character of the site. So what the council asserts is that its rurality and openness is a key factor and acts as a check to, I think I should say, sprawl or development. Now, so that's erroneous, as we shall set out in a moment. But just staying with the matter of approach, you'll recall the council draws upon the Marlowe decision to support the proposition that landscape quality is relevant to purpose A. But, sir, the decision doesn't, in fact, support that. So firstly, when you look at paragraph 44 of the Secretary of State's decision, what it's concerned with is concerned with applying the main points in the PPG, whether the land in that instance had existing development, whether it was restricted by physical features, and whether its development would be incongruous. The reference to settled land, lakes, buildings and boundaries and squaring off as the cross-references when you look in the paragraph to the inspector's report, the IR show, are references to the evidence which might be relevant to those key PPG questions on purpose A. So Mr. Stroud was misreading the paragraph when he took it to be an example of the Secretary of State relying on landscape character issues rather than applying the PPG guidance, which the Secretary of State, he had issued less than a year before. So the fact that the Secretary of State disagreed with the inspector that the site in Marlow was grey belt is reasoned in that paragraph, paragraph 44. It's an example of the application of the PPG, not an example of disagreeing on the basis that landscape character considerations should be viewed as relevant to the spatial policy of Greenbelt. Similarly, sir, the council drew your attention to the Lancaster decision. That was where the inspector found the land in question to be grey belt. Now, the point made by the inspector there that it was wrong in terms of purpose B to rely just on the quantitative measures of site size and size of gap. They don't apply to the appellant's case here. Reliance is placed on all aspects of the PPG guidance, including the fact that there would be no perception of the towns having joined or merging such that their separate identities are lost, indeed on the Council's and Rule 6's own evidence. So I just touched, before we get on to the key points again, on the Arup work being material, touching on the same issues. Whilst not as important as the PPG, it is also the case that the Greenbelt purposes themselves haven't changed, and the task of assessing performance against them is long-standing, and hence the Arup work remains relevant. It was an assessment carried out against very similar factors indeed, when one compares its methodology to the PPG. And the Arup work on purpose A, and this is a quote in the italics, was based on assessing the following. One, whether the Greenbelt sub-area falls at the edge of one or more of the distinct large built-up areas. Secondly, the degree to which the Greenbelt sub-area is contained by built form and the nature of this physical containment, as well as linkage to the wider Greenbelt, including the presence of prominent physical features that would restrict the scale of outward growth and regularise potential development form. And thirdly, the extent to which the edge of the built-up area has a strongly defined, regular or consistent boundary. So point one in that methodology maps directly onto the PPGs adjacent to a large built-up area. Point two relates to the physical feature in reasonable proximity that could restrict or contain development. And point three's reference to regularity and consistency of the existing urban form take us straight through to the issue of whether development will create an incongruous pattern of development. Now, so that specialists like Arup were assessing the strength of contribution to the unchanging purposes in much the same way as the PPG spells out should come as no surprise. Now, in a similar vein, as the inspector in the Marlowe appeal said, rejecting an argument just like the council's here, there's nothing complicated about the idea of strongly contributing to purposes. And it's wrong to suggest that work like the Arup assessment is rendered useless by the advent of the PPG. Here, as you know, Arup did not find that the site made a strong contribution to purpose B, for instance. And I note in the footnote, obviously, how they dealt with purpose A, which doesn't assist. So reliance on landscape character finally, just to make the submission after that, is legally erroneous. What of the additional extraneous consideration, rural landscape character, that the council places such heavy weight on? This Greenbelt purposes judgment must be exercised lawfully and exclude irrelevant considerations. And as you know, Sir, Greenbelt is a spatial restraint policy, not a landscape policy. As a result, purposes A and B are nothing to do with landscape character or whether rural character is valuable. That's a point of considerable importance because the contribution a site makes to landscape character is a legally irrelevant consideration when asking whether a site operates to check the unrestricted sprawl of a large built-up area. If a site were indeed contained by physical features which checked sprawl, it would not, we would submit, sir, be a lawful application of the policy at 155A of the framework, nevertheless to conclude that it performed strongly against purpose A because of its rural or pastoral character. But, sir, just turning to the facts here, leaving that legal point aside, no previous assessment has ever suggested this. That's the last point of context. Nobody's ever tried to reason that the site plays a strong role against purpose A or B before the evidence in this appeal. It wasn't the view of ARAP, as we've said, using substantively the same prompts as the PPG or CSA, or the view of the council when it allocated the site in 2021, nor was it the view of Inspector Fagan in January 2024, nor the view of council officers in 2025. It'll also be recalled, so that Mr. Cannon, KC, giving an independent view, but with a detailed knowledge of the site, having represented the council in the last appeal, advised that there was no evidence on which members could form the judgment that the site was not Greybelt. None of the representations made by consultees or objectors undertakes a detailed review of the PPG guidance to assess the site. And I've given you there, so the reference in the committee report where all of those representations are summarised. You can see that there. Against all of that, members rejected the Greybelt status of the site without any ostensible reasons, and now the inquiry hears from two landscape witnesses, neither of whom had visited the site before accepting the case to argue it was Greybelt. These points are not the answer to whether the site is Greybelt, but so we would ask you to accept that they amount to considerable corroboration of what, when one comes to it, is really obvious. And so I turn pretty briefly to the purposes. Purpose A, the purpose is about checking not just sprawl, but unrestricted sprawl. That's to say development spreading out in an unfettered, untidy way into the Greenbelt. So whilst the site is free of existing development, that is expressly coupled with, and I quote it again, lack of physical features in close proximity that could restrict and contain development. Now, so self-evidently, as Ms. Backer accepted, this is a site which enjoys physical features in the form of the woodland and roads in close proximity which could restrict or constrain further development. Those features, therefore, would comprehensively halt the unfettered spread of Radlett eastwards. Development would extend from Radlett onto the site, but would not spread out untidily and without containment into the countryside. The roads are old, they're permanent, heavily trafficked, and have established firm boundaries which have checked the outward sprawl of Radlett. There's no evidence of the roads disappearing or the golf course to the east of the Shenley Road disappearing, or the associated trees, including the Theobald's Wood. The woodland plantation is accepted by the council to be a restricting feature, and as Miss Backer accepted, the council doesn't suggest that the woodland should be regarded as temporary. Therefore, sir, it certainly is a defining feature of the site in Greybelt terms. Turning to the other key PPG guidance points, the roads and the way Radlett's residential areas have developed between them through the former Newberry's estate mean that the pattern arising from developing the site would not be incongruous. Miss Backer accepted that, and the correct way to consider incongruous was to ask whether what is proposed would be jarring or negative. The site wouldn't poke out into the countryside or look nothing like the kind of urban morphology that one already has in the residential area adjacent. By contrast, so it would be a continuation of the settlement pattern. And again, with respect, that is plainly the case. The council's case was in any event rather unclear as to the relevance of the scheme's specific details when considering this question of incongruity. Mr. Stroud's position, you may recall, was that the scheme details were not relevant at all to this judgment. And if that were right, obviously the points about density and scale made by Miss Backer would be irrelevant. But I turn to those just in case. Scale and density. To the extent that the council also seeks to argue that the pattern would be incongruous due to scale and density, I make the following points. Firstly, the 2 to 2.5 storey housing, only a small amount, obviously, of the latter shown on parameter plans, is not jarringly out of kilter with the existing urban area. The density of 195 units on the site would be medium, but not radically different from the existing area, noting, as Miss Brockhurst did, that the facing Newbury's Avenue edge is intensely developed, with very few gaps and similar heights on higher land. Density is hard to perceive, so as you know anyway, on the ground. This point about a jarring proposed character was advanced by objector and rejected by Inspector Fagan in 2024. Moreover, as the inspector said, the density needs to be optimised to make an effective use of land, and of course the council itself allocated the site for the same density in 2021. So the previous inspector was right to find the site performed moderately against purpose A, because it does not. Rural character. Turning back to the other points raised by the council and objectors, the rural qualities of the site in landscape terms are relevant LVIA terms, but they don't play a role in applying, as I've said, the spatial policy test of purpose A. The PPG says that land which makes a medium contribution to purpose A is probably likely to be affected by urbanising features. Now, so that's a point about whether they are or are perceived to be sites affected by development, in other words, the opposite of greenbelt openness. But the council and Rule 6 party go much further than this and say the rural qualities of the site indicate it performs a strong role in relation to the spatial policy purpose of checking unrestricted sprawl. And so, as I've said, that argument is objectionable in principle, and it's wrong on the facts here, because the rural landscape character of the site is accepted by the council not to be the reason why development hasn't occurred on it. If the site were grey-belt, the council accepts, paragraph 11D would indicate that permission should be granted. So the landscape character of the site, is not the thing that is, in Mr. Stroud's words, keeping sprawl in check. Permission would be granted, we all agree, if the site is recognised as grey-belt. It's the green-belt designation which has, before the 2024 MPPF, kept development here, to use Mr. Stroud's words again, in check. The reality is that the council's case is effectively an argument that the site can't be grey-belt because it's green-belt, a circular or question-begging approach which is wrong. It would have been better to stick to the application of the PPG, as the officers did. Similarly, sir, I just pick up this point about last pasture. The last pasture point is also a red herring. That too is really an attempt to turn a landscape character point into a greenbelt point. So it can't be right. It would mean any last ordinary pasture field with some trees on the edge of gardens would contribute strongly, even if the M1 was on the other side of it. So the Rule 6 party's woodland plantation point is rightly not taken by the council. It wasn't sensibly open to the Rule 6 party to submit the woodland could be removed on the evidence that you've got. Firstly, all features, however permanent, have a theoretical possibility of being removed, even roads, canals, railway lines, woods and so on. But one must look at the evidence in each case. Here there's no evidence of the woodland adjacent to the site being clear-felled. The evidence given was that there had been thinning, albeit that had ceased under the last licence. And as is obvious from going there, sir, a huge woodland is still standing there. Quite aside from there being no evidence it would all be clear-felled in the future, the licence conditions show that where clear felling has occurred, and you'll have seen this, they're on separate woodland far to the east of the appeal site, 10B, elsewhere within the estate, it has been subject to a condition for restocking. The only sensible inference to draw is that even if theoretically an application to clear fell any part of the woodland next to the site were submitted, it's inevitable that it would be subject to the same restocking conditions. For those who have managed to make it onto the site, unlike the objector landscape witnesses, you can see that the licence thinning has had no noticeable effect on it being a huge block of woodland, and so one doesn't need a ZTV to see that. The licence, fourthly, shows how little of the woodland is in fact thinned under forestry management. It's a business based on growing, felling and restocking trees, and there is absolutely no evidence that it is likely that the woodland would be removed or felled to a degree that would affect the role it plays in physically and visually containing the site. A couple of final points. So Mrs. Scott was unaware that her reliance on the proposed sale of the estate in which the woodland lies was unfounded. The estate is not for sale. The particulars she puts in the evidence show it's a huge area with buildings, potential previously developed land, PDL, and many other aspects than the woodland next to the site. As she accepted, it isn't likely that permission would be granted to fell the woodland and developed housing there. Again, sir, I ask rhetorically, forgive me, why are we even debating this point, given its lack of any evidential or common sense grounding? And I answer my own question, because the Rule 6's party's case, faced with what is self-evident about the site in grey belt PPG terms, has effectively tried to wish the woodland away, and so the judgment here, with great respect, needs to be more realistic than that. The only sensible conclusion on the evidence is to agree with Inspector Fagan that the site performs no more than moderately against Purpose A. The council say that Miss Brockhurst accepted that Miss Backer's weighing of landscape character and her overall view on contribution to purposes A and B was reasonable in judgmental terms. And so I just urge some caution and precision here. In re-examination, Miss Brockhurst confirmed that if the judgment in question was that the development would cause the merger or loss of separation, either physically or perceptually, between Radlett and Boreham Wood, then that would not be a reasonable judgment. She was also very clear she did not think that landscape character per se was a factor judging Purpose A contribution. So there has to be some rigour even where evaluative judgment's concerned, and to say that the site performs strongly when it's hemmed in and a considerable distance still from Boreham Wood and hardly prominent is not just wrong, but beyond the range of reasonable judgments when one looks sensibly at the facts on the ground. So in terms of Purpose B, briefly, this point, Purpose B, is about the merger of towns. Merger, forgive me for saying it, means joining. A site which performed strongly against this purpose would be one which is important to preventing the joining or the perception of joining of towns. Merger or joining would cause the loss of separate identities of towns. So hence the focus in the PPG on whether land, if developed, would mean that physically the land would take up a large part of the land between towns, or cause a sense that the two were no longer separate places. And strongly performing land would, if developed, cause those negative effects. And so, two things. Quantitatively, on any sensible view, the site is not a substantially, i.e. a large or big part of the gap, as Miss Backer accepted. Mrs. Scott acknowledged that this point in the PPG is about relative size, the site in question versus the relevant gap. And so the site is not a large part, relatively speaking, of the nearly 1.5 kilometre deep tract of land between Radlett and Boreham Wood. It wouldn't lead to the actual merger, obviously, of those places. It would physically draw the two closer together, but that isn't enough for it to be a strong contributor. And again, with due respect to Mr. Fagan, his paragraph 20 to 21 reasoning, when you go back to those, can't be right or wouldn't be right in the context of applying the PPG guidance on Purpose B. A site needs to be assessed against the current baseline on its own terms, not by considering whether, if a whole number of such sites came forward, the purpose would be offended. And I've just dealt with a legal authority, so which I've said you're aware of, I'm sure, but we'll send it obviously through the case officer just to deal with that point. It's a point just putting in context, really, sir, what Mr. Fagan was dealing with there in the pre-PPG world, this point about death by 1,000 cuts and definitional harm. It's not a purpose about the PPG guidance now, though. So in terms of perception, its development would not cause, the site's development would not cause the perceived merger of Radlett and Boreham Wood, still less Radlett and Shenley out to the east up the hill through the woods. It's impossible to say, and was not said, that post-development you'd cease to know whether you were in Shenley, Boreham Wood or Radlett, or be able to perceive them as separate places. To apply the PPG, the site's development, and I quote it, would not be likely to result in the loss of visual separation. As Ms Backer accepted, that doesn't say weakening or lessening, it says loss, because the policy purpose is to prevent the merger of towns. Perceiving that two towns are very slightly closer together, but are still distinctly and obviously separate, means that the land in question is not a strongly performing site. The fact that these are towns of a certain size is nothing to the point. The focus is on the gap and the experience of separation, not the size of the town. The site visits will have shown that one experiences Radlett and Boreham Wood as distinct places as one travels up and down Theobald Street, with the distance, the topography and the vegetation all playing a part. The site is relatively small, a sequestered part of that gap, with no intervisibility with Boreham Wood. Indeed, sir, you would only glimpse it when you are right up by the rest of Radlett on either of the roads. So, and again, sir, at the risk of labouring the point, the new national policy is not about land having any contribution to purposes A and B, it's about whether they strongly contribute. And whilst the development might lead to a marginal effect of drawing together, all that means is that it should be assessed as performing weakly or moderately. Given the hyper-localised views and the lack of any real views along Theobald Street, I should say, not just north of Gray's Inn, Theobald Street, where the journey to Boreham Wood takes place, it's impossible, sir, to say there would be a strong effect on Purpose B. A judgment that it does make such a contribution falls into the category of assertions or judgments which are wrong to the point of being unreasonable. And so in conclusion on this, really the main point, the site should therefore be regarded, we say, as grey belt for the purposes of the MPPF, and we come back to the golden rules and why the appeal scheme is not inappropriate in a moment. So I turn to character and appearance of the area much more briefly. In character terms, the site is not significant. In landscape terms, it's agreed not to be designated for its landscape or scenic value, nor is it said to be a valued landscape, and there is no suggestion that the landscape effects are such that it would cross the threshold for significance in EIA terms. In other words, it would be so significant that the regulations would be engaged. Pleasant though it is, sir, the baseline here is that the field is a visually contained pasture to which there is no public access, with some urban influences and no current recognised ecological value, the field, NB, not the wood, the field. Whilst the Council sought to stress the need for consistency with the judgments of Inspector Fagan in relation to landscape effects, it is worth noting that no landscape expert before this inquiry shared his view that the year 15 impacts on the character and appearance of the area would be substantial. Indeed, even on the site itself, the Council and the appellant agree that the residual, in other words longer-term landscape effects, would be no more than moderate, which is some way apart from Inspector Fagan's view that the effects on the site would be substantial adverse. That alone would form, we say, sir, a cogent basis for taking a different view on the landscape effects. Ms Backer acknowledged that longer-term or residual effects are more important than those which would be experienced whilst landscaping is establishing. Turning to the main harm, though, so the loss of the grassland pasture, to the extent that there was one, the judgmental debate essentially comes down to the permanent loss of the grassland on the site itself. The other features of note, importantly the woodland, are retained and or would be improved by the scheme. Even taking care not to overemphasise the effect of the urban edge, which is actually, as you've seen, quite strong, particularly during the winter months, the overall value of the site is no more than medium. Can you cross out then those stray words I've added at the end there? Sorry. Inspector Fagan was silent on the amount of weight he attached to the landscape harm he identified last time. The weight must be seen against the scale of the effect and the sensitivity of the receptor. Here the receptor is the character and appearance of the area, not the site itself. a substantial adverse effect on one element, in other words the grassland, of a highly enclosed medium value site can only sensibly carry limited weight when considering the impact on the character of the area. And so that's consistent with the agreed position with the council. There's no freestanding landscape reason for refusal, indeed no reference to it in the recorded minute, which was then translated by officers into that reason for refusal. And so that means that the council does not suggest that the appeal scheme would have an effect on landscape such that permission should be withheld on that basis alone. And whilst there would undoubtedly be a major and in landscape terms adverse effect on the open grassland or pasture component of the site and the rurality of this part of the edge of Radlett, that part of the site is no more than of medium value and is severed from any wider landscape parcel by roads and woods. Nothing turns in landscape character terms on the emotive suggestion that this is the last pastoral field, given that in landscape terms it doesn't, applying the Glivia 3 guidance, actually represent a landscape resource of high, or as regards the grass even medium high, value. In terms of visual effects, they would be very small indeed. There's no dispute that we're dealing with a largely sequestered site. The views are agreed to be limited and localised to Shenley Hill, as one would barely glimpse the appeal scheme through the woods from Theobald Street. Here, road users would either have come from suburban Radlett immediately to the north, or have journeyed through the countryside, turned 90 degrees to bring them effectively to the edge of the existing settlement of Radlett. Views across the site to houses are readily available. The development would not therefore introduce a new element into the existing views or materially change the sequence of kinetic views presently afforded to road users and walkers, or materially broaden the area over which the urban area would be perceived. And so those effects can only sensibly add limited additional weight, that's negative weight, obviously limited additional negative weight, to the impact on the landscape character of the area. So overall, Mr. Allen was right to afford relatively limited weight to the impact on the character and appearance of the area based on Ms. Brockhurst's judgment, which in respect of the impacts on the site and area at year 15 are essentially consistent with the other experts before you. He also noted as a separate but connected point that greenfield development around Radlett and the other main settlements in Hertsmere is inevitable if housing needs are to be met in line with the framework. Doing so on a sustainable site which has no ascribed designated, is not a ascribed designated value, that should say, forgive me, is not a valued landscape and is tucked away from wider views and overspill effects, makes every sense in landscape and visual terms. So I turn to other claimed harms and deal with the points taken about the golden rules. The Rule 6 party, these are the Rule 6 party's points, not the council, suggests that the golden rules are not met because the scheme fails to comply with paragraphs 156, 157 and 159 of the framework. I deal with them in this order. 159, the Rule 6 party's position is, with respect, based on a misreading of the MPPF. It's said that the golden rules are not met because the new green spaces required under paragraph 156C are of poor quality and fail to comply with paragraph 159, which they say is a golden rules requirement. So firstly, there's nothing to the allegation that the new open space will be substandard. The issues of the detailed design of the play space and boundary treatment, just as with the arrangement of the units to safeguard residential amenity, are matters which can be controlled via the discharge of reserved matters, all matters agreed at the outline stage with the council and covered by officers in the report. The main open space is sufficiently large and is in the same location, so as you saw that the council considered appropriate when it draft allocated the site in 2021. The second, sir, and coming to paragraph 159, that paragraph is expressly not part of the, quotes, requirements of the golden rules, which are said to be and are set out at paragraphs 156 to 157 of the framework. And so that point is made plain both by paragraph 155, that should be C, shouldn't it? 155C. Is that D? It is D, is it? I beg your pardon. 155D, yes, you're right. 155D and footnote 30. So that point is made plain both by paragraph 155D and footnote 30 to the framework. Cross-referencing in the framework, so it's obviously an essential part of its structure and is intended to ensure that the meaning of national policy is clear. The point is underlined by the structure of paragraphs 155 to 159, which begin by setting out the Golden Rule's requirements. Then in paragraph 158 deal with the weight to be given to schemes' compliance with those requirements. The content of paragraph 159 is concerned with landscape character improvements and local nature recovery strategy benefits, which the government suggests should accompany, quotes, the improvements to green spaces required as part of the Golden Rules, i.e. paragraph 156C. Not that those matters are required as part of complying with or falling within the Golden Rules. So that's not to say that those things should be ignored. They are outcomes sought by national policy. But it is a misunderstanding of the framework to treat those additional policy objectives as forming part of the Golden Rules themselves. And thirdly, so the Rule 6 party overstates the whole point. It refers to the PPG on this point, but that makes it clear that the developer should consider how to do various things, including assist with NNRS objectives being met. That isn't the language of policy or procedural requirement, let alone something which indicates that it's a critical policy requirement of qualifying for something as important as the Golden Rules. The prospective benefits of improving ecology across an area are things to consider, not which must be met. And so the Rule 6 party's attempt to convert it into a much higher order requirement is at odds with the actual language used to describe it. But so in any event, the scheme plainly complies with paragraph 159 of the framework, because firstly, the new and open green spaces would be suitably landscaped so as contribute to the landscape setting of the site, and of course that's a matter of detail. And secondly, the open spaces to be provided are agreed with the relevant authorities to be accessible to the public and quantitatively sufficient with precise qualities to be agreed through reserved matters. Finally, sir, through the delivery of an agreed 20% BNG, both on-site and off-site, it would contribute towards the realisation of the outcomes of the LNRS by improving land identified for having potential for habitat creation or nature recovery. That A3 overlay drawing, sir, which we gave you, shows, as Mrs. Scott acknowledged, that the scheme, through its BNG obligations, would bring about the improvement of two areas beyond the red line of the site, but within the control of the appellant. The improvements would be to neutral grassland and to woodland, in other words, the same or very similar to the indicative categories of potential improvement set out in the LNRS, and would therefore comply with the policy in paragraph 159, and I quote again, where land has been identified as having particular potential for habitat creation or nature recovery within the LNRS, proposals should contribute towards these outcomes. Now, so we're not seeking any further weight to be given as a result. We just note that the way the ecological improvement scheme has been designed also happens to meet the policy objective of paragraph 159. The point made to Mr. Allen about the PPG on how BNG, that's too many acronyms, how BNG relates to the LNRS goes nowhere. That simply shows that the BNG provided here, off-site, coincides with the LNRS improvement areas too, as Mr. Allen said. And it's no criticism that it's occurred as some coincidence, as it was put to him. The LNRS long postdates the application scheme, and it happens to accord with the guidance. So it's of some note, sir, that neither the council nor the county, so the LNRS authority, obviously the county, raises an objection to the scheme in relation to the LNRS, let alone connecting it with Golden Rules compliance. On sustainability, sir, so the Rule 6 party claim that the site is not a sustainable location and therefore one of the fundamental requirements of the grey belt not inappropriate suite of policies in 155C is not met. That's what they say. However, it's common ground, sir, between the council and the appellant that the site would be sustainable, which is consistent with the consultation response to the Highways Authority and the findings of Inspector Fagan at paragraph 56 of his decision, who recorded that the site was in an undisputed accessible location. Moreover, at paragraph 93, he afforded weight in favour of the scheme by virtue of its accessibility and transport improvements. The scheme would not have a detrimental effect on highway safety during either its construction or occupation phases. There's no objection from the Highway Authority in that regard, and these points were rejected by the last inspector. The regulation of construction traffic, including the correct vehicle routing, is a matter within the control of the Council via Condition 14 and the SEMP, which we dealt with earlier on today. So on the Golden Rules points, as agreed with the Council, the scheme would meet the Golden Rules, a point which attracts, and again an agreed point, significant weight in the planning assessment due to paragraph 158. And that's one of the main differences between the previous appeal case and this one, as Mr. Allen said. Smattering of other issues on the next page. So it was suggested that there might be an adverse effect of development as proposed on the water supply aquifer. Affinity Water, which is responsible for the operation of the Chalk Aquifer, was consulted on the application and, subject to the imposition of conditions which we've dealt with, was satisfied there would be no adverse effect on groundwater. The Council, in common with your colleague, was right not to identify any conflict with those policies I've listed there of the Radlett Neighbourhood Plan, or at all, contrary to the suggestion which Mrs. Scott makes again on behalf of the Rule 6 party. But in any event, and for completeness, the Neighbourhood Plan was made in May 2021 and makes no provision for housing and does not therefore engage paragraph 14 of the framework. The layout in the parameters plan puts the open space near the bungalows so that there is no chance of any cramping or harmful effect on their setting, and there's no force or in any wider complaint about the relationship between townscape character and the ability to design, that should say, I think, design the new scheme properly at reserved matter stage. There's no current ability, NB, so there's no current ability to deliver the neighbourhood plan's aspiration for a connection across the site, but the scheme would deliver a connection. As Mr. Allen said, not only was there no objection from Mr. Fagan on points like those raised by Place Services in the context of this application, but Place Services themselves do not object in principle to the scheme. The Rule 6 party would like Place Services views to represent a full-blown objection requiring what was described as an overhaul of the scheme parameters, but that's not what they said. Most, if not all, of the points they raise can and no doubt will inform the detailed stage of the scheme if and when it proceeds. That was appropriate, so at the outline stage, where such consultees as Place Services may raise detailed points but will not have an objection in principle. Outline applications are for the principle, not the detail of the scheme, something the Rule 6 party's case seems to have lost sight of. So I finish there with the planning balance and the conclusions. It is, as you know, the appellant's case that the site is clearly grey belt and meets the golden rules. If you were to accept that, no party suggests that planning permission should not be granted. If the development were not grey belt, there would remain a compelling basis on which to grant permission. The Council would like to suggest that in such circumstances, the decision by Mr. Fagan effectively gives you the answer, but that is far from correct. Not only would the harms require full evaluation, bearing in mind the points we made earlier about the weight to be given to landscape and visual effects, but there is another significant agreed benefit, the Golden Rules compliance under paragraph 158, which applies even if the scheme is not regarded as grey belt. Furthermore, the severe worsening of the Hartsmere housing supply situation was not envisaged by Mr. Fagan, who at most was sceptical about immediate improvement. It would be, sir, an error to accept the argument that effectively the VSC balance where it engaged is effectively a rerun of 2023 to 4. In any balance here against the harm to the green belt, which is to be given substantial weight once, and in the footnotes I deal with that old chestnut mistake which is repeated in the Council's closing submissions about giving every single bit of green belt harm individual substantial weight. That's wrong. And the limited weight, due to adverse impacts on the character and appearance of the area, there would need to be considered the very substantial benefits which would come forward if permission would be granted. And I touch on those really briefly. On housing supply, Sir Hartsmere's enduring and worsening problem, The council can only now demonstrate 0.98 years land supply, with no hope of making up the shortfall through the plan-making process in the short to medium term. That equates to an absolute shortfall of 4,868 homes, which so is colossal, and to give it some context, equates to an entire settlement roughly the size of Radlett itself, with its around 10,000 population. Size of Radlett itself. The shortfall is against the minimum requirement of the standard method, paragraph 78 of the framework, and to give the contribution of 98 market or 195 overall, anything less than the highest weighting in the planning balance would be quite wrong. Mr. Stroud's downplaying the weight here due to there being only 98, because it's 50% rather than 60% last time, is untenable. It was also inconsistent with the weight that a senior inspector, Mr. Prentice, gave to meeting part of the 0.98 shortfall in December of last year. The same has been true in a number of other recent decisions here, and to which we say the principle of consistency applies, because the relevant point, how much weight to give to a 0.98 years supply, is exactly the same. Also, the doubling of the shortfall was not and could not have been anticipated by Mr. Fagan, who, as I've said, only doubted whether it would improve in the short or medium term. And so one looks in vain in his decision for any reference, obviously, to the awful collapse of the housing numbers since 2024 in Hertsmere, or obviously for reference to policy changes to housing numbers being required, which hadn't come into existence at that time. Sadly, so we are where we are with the numbers, and we have a national policy requiring housing needs to be met. The unmet need is almost certainly worsening as well. You'll remember that document, sir, that was put in, I think it was, as the document about Hertsmere consents relied on by the Rule 6 party shows. Miss Rubinson. Yes, Mrs. Rubinson's document, extract. What that shows, sir, is either those consents are within the 0.98 years supply, given their dates, 2024 in the main, or they fall in the year after the base for the 0.98 calculation and show that only around 75% of the standard method requirement was met, hence showing, of course, the shortfall growing and growing. Moreover, sir, as we've said, it's inevitable that to meet anything like the need derived from the standard method, that the Council will need to expand its higher order settlements like Radlett, as it proposed to do before, and make Greenbelt allocations. As Mr. Allen covered in re-examination, even at the moment with a housing requirement that appears to be below the minimum required by national policy, the Council is consulting on releasing Greenbelt sites around Radlett, partly on the basis that woodlands hem them in with enclosure, something which will ring a bell when thinking about this site perhaps. Corroborated by those other very recent decisions, so Mr. Allen was right, we say, to afford very substantial weight to the benefit of new market housing, and Mr. Stroud was wrong to call into question the ability of the scheme to make a meaningful contribution to the present 4,800 home deficit against requirement. Mr. Allen, you'll remember, wasn't tested on the evidence from Carla Holmes annexed to his proof that homes would be delivered on site by May 2028, assuming an April 26 consent. There's no dispute on affordable, that the 98 affordable homes should carry very substantial weight. That must be right, given that the scheme would amount to 10 times more than has been delivered in the past 12 years, and the scale of the unmet need. This is one of the most unaffordable places in England, and at some point the nettle must be grasped and some affordable homes delivered. In terms of education, the provision of safeguarded land for the primary school should carry significant weight. Events have moved on from the evidence before Inspector Fagan, with it now confirmed that the appeal site is the only show in town, as it were, to expand the primary school. Moreover, as Mr. Allen pointed out, paragraph 101 of the framework provides that significant weight should be placed on the importance of new, expanded or upgraded public service infrastructure when considering proposals for development. Mr. Stroud's reliance on Inspector Fagan's conclusions without grappling with that material, and therefore the changed context, was the flaw which led to his decision to only attach limited weight to this benefit. Again, I just record golden rules, compliance, significant weight, and then on ecology and the economy, The provision of 20% BNG and economic benefits should both carry moderate weight, we say. The provision of BNG in this instance is therefore 10% above the requirement of law and policy. It also contributes to realising, as I've said, the objectives of the LNRS, and is of course double the requirement, and that's of BNG. Moreover, the economic benefits have been quantified, unlike before Inspector Fagan. The unchallenged conclusions are that the scheme would deliver 115 construction jobs and just over £1 million during the construction period, and an additional £327,500 additional £327,000 additional expenditure in the local area, which is 3% of the 2017 spend in the whole of the Radlett local area. So consistent with paragraph 85 of the framework, significant weight, we say, should be attached to those effects. So overall, sir, and this covers obviously the point that we make about VSC, those benefits, coupled with the additional benefits of the safeguarded land for the medical centre, the enhancement of the rigs and improved connectivity, are clearly very, very weighty indeed. Very special circumstances embrace considerations beyond just the benefits of the scheme, the inevitability of Greenbelt release around Radlett, the fact the site was draft allocated in 2021, the lack of any plan-led solution to the housing need in the short to medium term, all bears on whether the circumstances here are very special. And Mr. Stroud was therefore wrong to say that if the site is not Greybelt, the blueprint, as he put it, for refusal is set out by Inspector Fagan. The Council's own officers, sir, didn't take that view when they advised in the alternative that permission should be granted because very special circumstances they thought existed in September of last year. And so they were clearly right to do so. Ignoring Greybelt, the national policy context has only strengthened in favour of delivering homes even where there would be a measure of harm, e.g. to non-designated or valued landscapes. The unmet local need has only intensified. The factual and evidential basis, particularly on the education provision and economic benefits, is materially different to that before Mr. Fagan. The only logical conclusion is that any harm to the green belt and landscape would be clearly outweighed by planning considerations comprising VSC, even if the site isn't grey belt, which of course it plainly is. So in terms of the overall points, officers, you'll remember, warned members about the potential award of costs of an appeal in light of the proposed resolution to refuse. There were and are no sustainable reasons to withhold permission because it is on the facts unreasonable to deny that the site is grey belt. Its green belt designation plainly has functioned as a brake on its development for housing needs in the past. I say wryly, as the appeal decision in early 2024 exemplifies. But that kind of outcome on sites like this is precisely why the government has so radically overhauled national policy in December 2024. The framework now tries to prevent a perpetuation of that outcome and remove the dead hand of Greenbelt policy from preventing sites which are not strongly representative of Greenbelt purposes from playing their part in meeting the country's deep housing crisis. And so for those reasons, subject to obviously the conditions in the 106 as discussed, we would respectfully ask that the appeal be allowed and planning permission granted. Thank you, sir. There is a point about timing on the 106, sir, that I just want to come back to you in a moment, if we may.
I'd ask for 14 days on the 106.
Yes. Is that okay? I just wanted to check that, sir, because that would make it the 20th, I think, of February.
I was going to ask, was that working days or
I
not?
think just 2 calendar weeks would be fine, so thank you. And it connects to that other point which was made, I think, through, I don't know where it came, but through the council. I don't know whether it came from Mr. Stroud, about making sure that the 106 had been up on the website for, there's no statutory or legal period, but I think it only went up yesterday, the final version, and I wonder, sir, whether you were going to do this anyway, not close, as it were, until the 106 had been received, so leave it up for a couple of weeks, so that if anyone did have a point specifically about the 106, not about anything else, they could make it in that time, that might cover the position. I think the council.
we went through it in some detail. I was quite happy with that. I don't think there was any concern from anyone that any of the calculations or how those figures had been come to was raised with concern. That was my principal concern there, in particular in respect to the education contribution that had been disputed and then wasn't. I want that to be quite clear to local residents as to why that was, and I think that was fine, and they seemed remarkably happy with that, so I'll be quite happy to close the inquiry on that basis. It's gone, they've had a copy of it, they'll run through it today, and I don't think there should be any surprises there. I'd touch wood with that.
Yes. I mean, we're in your hands, so I'm just, it's not really our point, I'm just responding to the point about keeping the 106 that came from the council. To some extent, I can see the point. What we don't want, obviously, is somebody saying, well, I had a point to make about the 106 and I didn't see it until the 15th of February, etc. And that I think that's the only point that was being made, and I can see some slight faults to that, I have to say.
Fine, with an abundance of caution, we can leave it up and
if you wouldn't mind,
for
so I
another
think
week
that would
if
be
we
helpful.
want to. Okay.
Yes.
And on a not dissimilar subject, arriving in my inbox just recently were two late representations from local residents, which I don't think, as far as I understand, raise any new issues. I haven't seen them, but I asked my case officer, so all be well, I would generally look to accept those, and I'll send copies
I haven't seen
parties.
those. So, okay. Did they? Is there anything are we happy with them? Yeah. Okay. We're not raising any point about those.
Thank you. Done that. Okay. In that case, if that's housekeeping done, we move on to any cost applications that there are.
I don't know whether it's made it through to your inbox.
No.
Oh, I beg it. We didn't send it directly. We sent it to the council. I'm told.
That may even be there now. I've got an inquiry document list as well. Thank you for that.
We'll send it through the case officer now, sir. Okay.
So that's essentially a cost application in writing.
Cost application in writing, as we discussed, I think, on the second day on Wednesday. And obviously the council needs time to respond.
Yeah.
Yes, and as I flagged up, may well be making a counter application. I haven't had a chance to look at it. We've seen it. It came in at 2 o'clock, for which many thanks. So I'd suggest in the first instance we adopt the 14-day timing, seeing as that's there for the 106. We'll obviously try and respond sooner than that, just to give ourselves some cover. And I don't know, we flagged earlier, it is likely we would be making an application ourselves, dealing with the costs of having incurred in dealing with it, but I won't say that because I haven't read the cost application yet, but I just flagged that up. And if we do, obviously the appellant would want to respond to that, no doubt, and we would have the right to respond to that. So it might be worth saying 14 days for us, and then thereafter the appellant obviously has a right to reply to that application, and we would have a final right to reply to any response to our application if we made one.
Okay. So on that basis, I'm going to essentially leave the inquiry open to run for some time yet to resolve those final 2-3 issues in that regard. Okay.
Yes. So, I suspect I know what the basis is. I just don't want to prejudge my position.
I'll respond, and maybe responses from that. I will appreciate that.
Yeah.
Okay.
I think I may have signally failed if Mr. Cosgrove doesn't know what the basis for the cost application is, but
I'm sure I do, but I don't want to.
No, I'm joking. Just in terms of the time frame, though, so I mean, I'm absolutely happy for the 14 days. We would normally have a kind of final right, if you like. Extremely unlikely, I think, in this case, to respond to that. I don't know whether it's possible to concertina, if the council is minded to launch its own riposte, then we can maybe deal with all of that, including our reply, within the 14 days. I just don't want to leave it too open-ended, that's all, in terms of the timescale.
I'm keen that things don't become straggly by the end, but I don't think we're necessarily in that grounds just yet. And I'll deal with any of those issues if it and when it comes up.
Yeah.
Mr. Warren.
Yeah.
I was going to suggest, just as something to think about but not make a decision on, perhaps, that if the council is in the end going to launch its own riposte, as I've said, that it does so within the 14 days, and then we have a week.
I think if we do, it'd certainly come at the same time as a response within
Okay,
that period. I'm not suggesting waiting to. I think it would be tied up with it. So yes, it's just I don't want to commit myself to doing that before I've fairly read your application.
No,
so,
of course not.
But if one did, it would be a response with an application at the same stage, and then thereafter I'm very relaxed about timings.
Yes.
7 days
That sounds
thereafter,
sensible.
both respond 7 days thereafter or something.
That sounds,
Yes, that sounds right. Fine.
Yeah. Thank you, sir.
Excellent. Okay. Okay, so I have everything. I did have that document list, inquiry document list as well, come through. So thank you for that. I'll happily adjourn the inquiry there.
We'll have to email it
Liaise
through.
with it.
We'll have to email it through, sir.
Okay, so sorry, I've got a copy of one. Yes. And you haven't seen it. I'll leave it to you then to have a look at that. I presume you've been copied into it.
I don't know. I don't. Well, you've got some
Well, I
magic.
only glanced
someone
at it,
in the
although
ether
here's
who
the
sent you
inquiry document
lists.
list. Excellent, and I haven't looked any further than that, so I wonder where that's come from. Excellent. Good randomness. Well, okay, I'll make sure a copy of that is sent on to you anyway, and you can see what you make of it. I'll adjourn then. We'll most likely close in writing then. Thank you very much. Thank you for assistance. Thank you.
Thank you, sir.